difficult.
Case was
If one
posted.
starts jumping, then there is no end to it, you know. Then every day, half an hour, 45
That
minutes.
is
on
that I
mentioning-
understand, my lord. Kintu
I'll
cost-
make it, please cooperate. I'll see that all the matters are taken up within 15 days.
Okay.
I will sit overtime also if required. Till 5 o'clock also I'll ready to sit. But we will finish it up. Please cooperate. So that there will be no grievance from any side. Okay.
And 2016.
See, once you jump, then everybody will have the complaint. See,
My lord,
everybody knows what is the difficulty.
your
Please
lordship,
wait. Let us see
keep
how
the
it
order,
moves,
my lord.
huh?
Once
My lord, one CRLMC, my lord, of the year 2016, I have given the memo, my lord. The interim order was there that has been that has lapsed, and the court below is going to take up the matter. Can it be taken up tomorrow, my lord?
Not tomorrow.
Monday, then Monday, your lordship.
Yes.
once CRLMC.
All mentioning the same.
CRLMC, once CRLMC, my lord, in respect of the co-accused, due to lack of sanction, this honorable court has quashed the proceeding. There was the interim order.
Your death sentence is over now.
ଅଛି ପୁଣି ଚାଲିଛି
Oh,
ମୋର
after that is over, then you mention.
ସେଟା ଦିଟା ବେଳକୁ ଆଜ୍ଞା ସେଟା ଦିଟା ବେଳକୁ ଏବେ ତାଙ୍କୁ ରିଟ୍ ଦିଆ ହେଇଛି ଫାର୍ଷ୍ଟ ହାବରେ ତେଣୁ ଡେଥ୍ ରିପୋର୍ଟ ଦିଟା ବେଳକୁ
What is the urgency?
urgency the trial court wants to order from this time. There was stay order till the next date, but the trial, since the case has not been listed, the trial court wants. So it will taken up
Even if there is a stay, since
Till the
it
next
not
date.
listed, the trial court is
well,
going.
till the next date. I have mentioned.
So next date hasn't come. Wait,
I have given
wait the next date.
That-
We'll
I
see.
have given the memo.
For leave this week, please leave. Let us understand what is happening. Thereafter, from
Next.
Monday onwards, we will try to
Yes, madam. Yes, madam.
rotate things.
Item number 31 in the lordship list, madam.
Yes,
Permitted to withdraw, already acquitted.
yes, that's the best thing you can do.
376 POSCO case, madam.
Okay.
In fact,
This
it
is
turned
the
hostile.
difficulty, my lord.
Huh?
Victim turned hostile. The prosecution filed a decline memo case, it closed.
Okay.
Pardon to make a mention, my lord.
Yes.
Criminal appeal number 91 of 2020, my lord. The appellant is a senior citizen and
When I was searching people, where were you? Every day, but after 2 o'clock, I kept on asking anyone, please come and argue. You didn't argue. Now the board is full. What can I do? You have to wait. The appeals up to 1994, 95 are also pending. And nobody is willing to argue what to do.
the appellant has convicted, my lord.
I can't help it now because the board is such, I can't help it.
Item number 35 permitted to withdraw.
35 withdraw. Very good.
Pardon, your lordship. Item 71, your lordship.
Yes,
On behalf of Dr. J.K. Lenka, your lordship. Dr. Lenka is suffering from high fever, your lordship. May be posted next week.
71. What is
71.
this matter?
Your lordship, that BDO matter, your lordship heard last time was
Uh-huh.
basically adjourned.
71.
Yes, your lordship.
Is it a heavy matter or?
Your lordship, regarding
Discharge application. Charge frame. Stay is operating. No stay.
no state of good.
Where is it? Yes.
Good.
Start. Any mentioning in VC? No.
Item 1.
Yes.
May I please, your lordship?
Yes.
But here, the application under section 482 CRPC challenging the order, my lord, framing charge under section 302 with other offences, my lord.
Hmm.
If your lordship will kindly come to page
Mr.
37.
Ragada was supposed to get
The-
yes, poison or something. What is it?
That is there. The point for consideration here is, my lord, can 306 and 302 both coexist simultaneously, my lord?
That will be decided at the end. You will be
No.
either convicted in 306.
No, my lord. Once the court takes cognizance, my lord, what is my humble submission before your lordship? Once the court take cognizance on the basis of the record, my lord, and the allegations, my lord, that the man has committed suicide. The very same court, my lord, framing charge under section 302, taking cognizance that she has been murdered. Can both run
I
simultaneously?
don't know. What are the evidences?
My lord,
Let us see.
material is that she has committed suicide by taking taking some tablets, my lord.
You are challenging the charge.
Charge, my lord, so far as 302 is concerned, not other charges, my lord.
Okay. Let us see the charge sheet.
My lord, charge sheet,
Let us see the order first. Charge
my lord, the order, your lordship will get it at page 37.
37.
7.
Let us see.
From third paragraph, it will be relevant. On
Yes.
perusal of the material submitted by the prosecution in this case, I am of the opinion that there are sufficient grounds for presuming that the accused committed the offence punishable under section 498, 306, 304,
Where are you reading? This is page
37, my lord.
37.
Third paragraph.
Okay. Yes.
On perusal of the material submitted by the prosecution in this case, I am of the opinion that there are sufficient grounds for presuming that accused committed the offence punishable under section 498, 306, 304B, 328, 406, 299, 302 and section 4 of the Dowry Prohibition Act. My lord. But this is my challenge, my lord. I am challenging on the ground that once you have, the court has taken cognizance that 306 has made out and the charge has been framed under section 306. The same court cannot again say that it is a case of murder. Simultaneously, both cannot run
What
together.
is the charge sheet?
Charge sheet is 306. With other offences, your lordship will find that annexure 2, my lord.
304B is also there.
304B is there, my lord. I am not challenging that, my lord. I am challenging the
302. Yes. What is-
With regards to 302, my lord, the charge sheet submitted on section 328, my lord. My lord, offence 328 says, my lord,
on 328.
Then
charge sheet submitted and also charge frame, my lord, administering.
Hmm.
to
Three.
stop in fine-
You are talking about
328, my lord.
328. Okay.
Stupefying drug with intent to cause hurt, etc., my lord. And when came to 328 is there, my lord,
Hmm.
for that reason and 299, my lord, for that reason, my lord, the offence is the
So what he says that 306, 304B,
My lord,
302 and everything you have club.
for that
So therefore,
299, 302, for that reason, my lord, the court taken cognizance 328 is there, my lord.
କୋଉଠି
They administer.
328 ଟା କୋଉଠି
ହଁ,
ଅଛି?
ଅଛି ନା?
ଚାର୍ଜ ସିଟ୍ ଫାଇନାଲ ରିପୋର୍ଟ ଫର୍ମ ଟା ଦେଖନ୍ତୁ
The-
ପେଜ
the mo-
18.
The moment, my lord, the court, my lord, form an opinion that it is a case of 328, my lord. For that reason, the court taken cognizance 299, 302, my lord.
କେମିତି?
That no illegality, my lord. And
ମାନେ ହା-
that happened, my lord, your also last occasion.
but how will you address 464?
my lord, I am not questioning those things, my lord.
Now, if there is an error, you are not convicted.
Exactly.
You are not convicted.
That
Higher
is-
offense
that
is,
is-
see, higher offense
but
is.
your lordship may kindly,
Stage, my lord. Before-
my lord, charge, my lord, I am supported by a decision, my lord. I will, if my lord,
Show me.
friend, that is
If 464 says that if there is a erroneous charge also, that
The-
will not
the-
vitiate everything.
my lord,
And all the points which you are raising today, I'll keep it open
Exactly.
to be argued at the appropriate
no,
stage.
my lord, keep it open, all right, my lord. Your lordship will kindly consider one thing, my lord, whether the same court having taken framing charge, having
If there is a
framed the
higher-
charge under
if there is
section,
a higher charge,
that is
and
correct.
you can be convicted in a
Lower offense. But if there is a lower offense, the court cannot take cognizance under the higher side.
302.
Supposing, my lord, in a 354 case, I am just giving one example, my lord. In a 354 case, my lord, because but the materials are there under section 354, my lord. Now the court will frame the charge under section 376 because
Anyway,
376
do you
is
have
the higher.
do you have any judgment?
I have got a judgment, my lord. Of course, I have not got the copy of the
Why
judgment.
installment?
ନାଇଁ ମୁଁ
installment
ସେଟାକୁ
can
କପି କରିପାରିଲିନି, that is ଛାଟୋଇ and 4 others
I'm
got a
passing it
state.
over, get the judgment, I'll dispose it. There is nothing in it.
My lord, there the honorable court
If you are covered by
of
the judgment,
UP,
then you
while discussing the point of law, my lord,
I'll keep everything open, sir, for you. Argue
Kale-
all these things. Because
କାଲି
you are
କାଲି
not-
କାଲି ଆସୁ ମୁଁ ସାଇଡ୍
କାଲି
କରିଦେବି
ତ-
ଆଉ ପୁଣି ରଖିଲେ ହଜୁର ସେଟାକୁ ପୁଣି
Monday go, Monday.
ମଣ୍ଡେକୁ
But don't stretch it further. Come, don't.
No,
come and discuss.
I am ready with the case, my lord. I am ready.
Yes, what-
କଥା ହଉଛି ଟିକେ ଡେରି ହେଇଗଲା, ମୁଁ ଆଉ ପ୍ରିଣ୍ଟ ଆଉଟ୍ ଟା କରିପାରିଲିନି. So that is my difficulty.
I know, but you don't have a.
Both cannot stand together, my lord. Both can never stand.
As far as the charge is concerned, and you will be
No,
acquitted.
my lord, but the court has
Then
taken
what I'll
cognizance
do-
of one fact.
Then
My lord.
what I'll do
The
is
facts are
306, 304, I will drop. You try, you
Three-
go for 302. And if
No, no,
you, if the
302
court finds the
if
lesser
there is any
offense,
material,
he'll,
if there, the medical evidence says it is a suicidal death. Medical evidence says it is a suicidal death.
the trial is segregated.
Materials on record shows that it is a suicidal death, my lord. So how the court can, on the basis of the material, whatever available before the court, my lord, the court cannot go beyond the
Okay,
materials on
come to
record.
the judgment, if that come to your aid, then we'll see Monday. Okay, next.
Lord, interim order is there, your lordship.
Interim order will continue. If there, I am not altering. Yes.
ନାଇଁ ସେଟା ସେ ପୁରା proceed କରି ଯାଉଛନ୍ତି court ରେ।
Yeah, Monday could put. Yes,
କାଲି
May I please your worship?
yes.
Whereas petition is being agreed with the annexer 12. The rejection order of the learned JMFC regarding getting the permission to go abroad to get
Permission to
the
go abroad.
passport. To get the passport. You know,
You
can
release a
peruse.
passport or permission to
Annex
go
one.
abroad.
Under annexer 1, he want to get the passport in
Where
lieu
is
of,
the impure order?
in lieu of lost.
Show me
Annexer
the
12. Annexer 12.
Annexure
Annexer 12, page 45.
45. Okay. Just read it.
And that's the last para. One, two, three, third para. Lords, may kindly got it. Peruse the case record and perusal of the case record. It found that this case of year
You
2000.
want to go for employment purpose.
I have already got an employment in the Oman.
What is
And-
the offense?
On
And
that reason, your worship last time also asked him to give some circumstantial documents so that the.
My lord, my lord, I have
Till yet
already
Mr.
filed.
not file a-
No, I have filed additional affidavit to that effect.
What is the offense?
My lord's offense is, let's me like peruse 147, 148, 341, 323, 325, 379, 506, 149. I piece the,
Party to the writing and all.
well, that is what FIR is I have annexed to last members.
But you tell me, if you go for employment purpose, you
Well,
will be
well,
staying
last
permanently
Peruge.
there. How will you face the trial?
For-
No, so
for
last
that
kind
reason,
Peruge,
the
last
court
kind
did not do
Peruge.
that. The
And
accused-
there are many other accused also.
Some-
like court
some
party
are-
is-
Now I
Yes,
cannot, Manas, with due respect, Martha, I now during the filing of the case, I had the valid visa, but now it has been lost its import.
I understand your
Manas, there is no chance of going the outside. But my passport was for the 10 years, it was
But you are
granted.
asking for passport for to go to
But at that
overseas-
time, why I am
overseas
saying,
for employment purpose.
your lord's may kind Peru, annexer 1, I have got the passport in the year. Kind
I am not
page
disputing that.
25 for 10 years, and it is valid up to 21/7/2031. After getting that, I have got a job in the Oman, and I had there, and I returned to this
You are not answering my
India.
question. You are not answering my question. It is a case of 448, 449 and all. There are many 148, 149
Yes, my
writing
yes,
and all.
yes, madam.
There must be many accused.
Yes, my lord.
Accused? Okay. If you go and work in Oman, how will you face the trial?
But in this regard, since 2008, the case is pending, and now only the charge sheet has been filed. So many accused has been to be appeared, and it can be granted for only one. My family is in the Odisha. My entire family is in
How
Odisha.
will you face the trial?
My lords,
That's
that
the
is the covered by this honorable judgment
me.
that, yes, ma'am. Since the pending of this case will not be a bar to get the.
No. How will you face the trial? You
No,
answer.
lords, may kind peruse
These-
I am
that-
supplying my lords. But that particular case, lords, even if the pending, they have been granted
One
the.
court we also held that the accused had not filed any document before this court in
Your lordship, may
supplementary
kind,
employment.
I'm
Detail
supplying.
of
the-
his journey and the time period for which the
Man,
accused
he is
wants to
going
stay.
to work there.
My lord, work there, my lord, he has to. Sorry.
You show me where you got the job. Or you go and start searching the job.
Now I have no job therein.
Achha, you will go there and search.
Because since 2023, I have lost. And I am before this honorable court.
Your application is you are going for employment purpose.
I have got an employment therein.
You show me some document that you got an employment.
Yes, your lordship, I have
And this
annexed.
is my appointment.
I have annexed, your lordship, can peruse.
Show me
I have annexed.
which.
Annexer 2.
Hmm.
Page 27. senior mold technician. In the year 2021, I have got the job and I was there. I came to Orissa on leave for treatment of my wife.
You don't understand what I'm asking. I'm asking whether today you have a job.
Exactly.
And it is a private job and due
Oh,
respect,
then-
my lords. My lords, in that regard, passport cannot be denied, my lords. I have relied upon the documents.
Passport I can release, but you will not go outside.
Yes, your lordship, I can pass that.
Passport release is there, no problem.
Yes, my lord.
Suppose a religious passport and a
Yes, my lord.
renewal, my lord, he can file application there, my lord.
No, my lord.
And here, my lord, he
My
file
lord,
them, go to
I have,
my lord.
I have, with due respect, my lord, I have filed 2 applications. First application was pending. Information was received from the passport authority that a criminal case was pending. I got a bail order from the London JMFC. Thereafter, I made another application. During pendency of that application, they were not taken any action. And I got an appointment to meet the passport authority. They advised me to get an order from the London JMFC. I got the order, impugned order.
No, the impugn order you are asking for depart from India for a reasonable time for his employment purpose.
My lords, that
Time
was-
is not there, job is not there, nothing is there.
But
And
at
you
that
want-
time, I have filed an additional affidavit. It is in the record, my lords. At that time, they have given me time to come here within 3 months.
No, you move a fresh application telling.
Yes, my lords, may kindly give
Right.
it. And considering the ratio of decided by the
1 minute,
Supreme
you
Court.
advise your client to write proper application. This kind of vague application, which court is going to allow?
It's about the
Right?
original.
You give it now, since you are the lawyer, you advise your client what to do
I think
in a
there are
better manner.
some other
I'll set
companies
aside it
for that.
and I'll send you to
That's right.
and remove right application. You will get released.
There are other.
Application
councils
was
that-
wrong.
My friend not there, my council.
Well, considering the ratio
No,
decided by the
this
Supreme Court,
application, this application cannot be allowed like this. You don't say, I will go for a reasonable period for employment without employment.
I am not disputing. Your lordship may kind Peruj. In the
The-
similar footing,
in
my
the-
lords,
in the-
this court
one
also
minute,
granted the.
1 minute,
Moment.
1 minute,
due respect.
I can't allow this. Wait, I'll just give you relief, right? Write down, in the present petition, petitioner has assailed the order, dated 17/6/2023, were passed by
Lani JMFC.
JMFC, Lakshmipur.
Lakhanpur.
JMFC Lakhanpur,
In
district of Jharsuguda.
GR number
147, 1407.
2008, whereby his application seeking permission to travel abroad for a reasonable time for his employment purpose has been rejected. It appears from the record that the petitioner moved an application before the court below seeking permission from the court to depart from India for a reasonable time for his employment purpose. Nothing is placed on record regarding his employment or employment. He has also not given the particulars regarding the period for from which for the period for which he wants to travel overseas. Therefore, the trial court has rejected the application, and counsel for the petitioner submits that in fact he was employed in a private company. Since he could not attend his duty, he lost the job. He submits that he is otherwise entitled to the passport which has been seized by the prosecution.
It is lost.
Lost.
It is lost.
He has lost. Then
It is the lost. In lieu of lost, he has applied. That is my submission. It is lost.
release. What will the court release?
But the question is, if he has to file a application before the court, that the case is pending, that may be ignored by
Yes,
the
there is-
court will given
For
order.
passport,
My
he
lord,
has to move such a.
my lord. Fresh application there. Passport apply kare, application that should happen.
Entitled to hold a passport, which apparently he has lost. Apparently he has lost. However, the application was not directed application was not moved in that regard. Hence, the trial court has rejected the application. In that view of the matter, the petitioner seeks to apply it to the court a phrase enumerating the detailed facts and molding with prayer, prayer. Therefore, he seeks liberty from this court, liberty from this court. Liberty as prayer is granted. The petitioner can move for a press application before the court below for appropriate direction. If such application is moved, the same shall be considered on its merit without being influenced by the observation already made in the MP note. With this observation, the petition is move proper application. Yes. First, you can apply.
Similar circumstances, this Honorable has already granted. I have got the judgment.
The application was not proper. I have given everything to you. Move an application. Application was so badly drafted. What to do? The trial court is also fixed. Yes, next.
Item 3.
I've given everything. You can move press application, you get the order immediately. Move the application immediately. Yes. Yes, sir.
During this case, my lord, the petitioner filed an application for cross-examination of the PW1, my lord. Because by that time he was engaged in a higher form, to that extent not able to cross-examine. That is a simple petition, my lord.
Show me.
Yes, my lord. Annex 1, page 5. That is the petition.
1.
Yes, my lord.
Next
Page 5.
one.
With your may I place, my lord? Therefore, pray that your honor will be pleased to grant this to allow this petition and to call for the said PW for cross-examination.
Where are you reading?
Prayer.
That day
Page 5,
petition
page
number 1
5,
was-
page 5.
Yes. Para 2, but read it. That day,
That
on that day,
on that
petitioner
day,
number 1
PW1 was present before this honorable court, and due to engagement before higher forum, their appointed lawyers busy at court work, the said PW1 could not be cross-examined if the said PW will not be recalled.
show me the impure order.
Improvement
Page
page 6, my lord,
Annex 2.
third paragraph, my lord. Perused the case record and found that PW1 Tapos Chakrabarti was examining cross-examination discharge on 2/5/2017.
No, that is this is the petition. This is the petition
Mr.
filed by this is the,
1 minute.
yes, my lord. Let me LCR
Show me
record.
the evidence.
My lord.
Show me his evidence. Tapas. Tapas.
I'll
Or that is the case action, my lord.
No, just bear with me for a moment to that extent, only to show that evidence.
Show
whether-
me the
Yes,
evidence.
yes, yes,
Tapas.
Yes,
Do you
ma'am.
have the
No,
copy?
that certified copy has applied.
Certificate copy I don't need. You give like this, I'll allow it.
No, that copy is not with me to that extent. Put up in next week, my lord. Even if Xerox copy, I will send.
Why are you filing this kind of petition? I don't know. But the court says that he has already been cross-examined. You say it is not cross-examined. Show me something he is not cross-examined. I'll allow.
Yes, my lord. I oblige to that extent, my lord. Who is fair to that extent? After producing the document, everything will clarify to that extent.
Can you bring it 2 o'clock?
No, that are in Potamuni, my lord. That are not in
Photocopy. Show me the photocopy. I'll allow.
That I can't say exactly, but he's in court, trial court, so that's why he may engage in any other court. That's why it creates. So if it
Don't
is
file
possible-
cases like this.
All right, if that is fine, that will take into consider after producing the document, my lord.
Why should I waste time on this?
One line, my lord, mention the defense counsel refused to cross-examine him. Why ordered it? They said they had this. See order time not refuse.
Give one opportunity. Why to waste time? I'm going to give you only one.
Also obliged to that extent.
Right now. Right. And in the present petition, the application of the petitioner, the petitioner is assailing the order dated 1/9/2023 passed by NGN. from
NGN, JMFC Rajnagar.
JMFC
In GR case.
Rajnagar, huh?
Yes, my lord.
Rajnagar in GR case
88 of
88
16.
of 2016, whereby his application dated
24/8/23.
24/8/2023, seeking direction, seeking to cross-examine PW1 has been turned down. It is contended by the counsel for the petitioner that on the day the petitioner, the PW1 was to be cross-examined, the counsel, defense counsel was busy in the higher forum, therefore he could not cross-examine the witness. Therefore, he seeks indulgence for this court in that regard. I have perused the record, perused the impugn order. It indicates that the trial court has rejected the application of the petitioner on the ground that the defense counsel has refused to cross-examine the PW1. Therefore, the PW1 was discharged. Taking into consideration the entire effect in the entirety, I am of the considered view that the petitioner is entitled to a singular opportunity for cross-examining the said witness. And therefore, the impugn order is set aside. Petitioner is afforded a single opportunity for cross-examining the PW1, that is Tapas Chakraborty. It is made clear that the trial court shall fix a particular date for cross-examination, and it is made clear that no adjournment shall be sought by the defense counsel in any ground whatsoever. If one opportunity, if the defense counsel will not avail the opportunity given by the trial court for cross-examination, the right to cross-examine PW1 shall stand closed.
Much obliged.
Yes.
One victim.
But file the document properly. What is this?
Much obliged.
And you take one day, again you will come with something.
Okay.
Yes. Next. And, yes. Password. Yes. Yes, sir.
Discharge again. Discharge. May it may be taken up next week. I have not gone through the file.
Okay. Next week.
Tuesday or Wednesday.
He'll give you day. Yes.
Item 6.
One request, man. By that time, my learned senior may take instruction relating to payment, because this is an allegation against the Miller.
He will come with all instructions. Don't worry.
No. Whether Miller has deposited the entire fine amount.
He will get it.
That is only.
Since you are
I could not able to get this.
seeking adjournment, let him do whatever.
Man.
He is there. Yes, sir.
At your instance, he has deposited. You
No. He has deposited so much.
And the lunchtime you tell him what is. Yes.
Item 6.
Yes, sir.
Right, prisoners. Here, my lord, the petitioner has challenged the order passed by the learned special judge rejecting his application filed under section 239 of the Criminal Procedure Code, my lord.
Yes.
Here, it's a short fact, my lord, involving the present case. The petitioner was the branch manager of Orissa State Cooperative Bank, Budheshwari branch, and during his tenure, while he was acting as manager, OSCB Bala launched a special house loan scheme for permanent employees of state governments.
Yes.
And during that juncture, it is alleged that around 43 employees of postal printing press, they applied for special loan, manner, housing loan. And their applications were forwarded by their salaried official, who is otherwise called DDO. And he has also signed in their loan application. Accordingly, my lord, loan was sanctioned to the tune of 21,20,000. But the reasons best known to the loanees, they did not pay the EMIs in due time. So a case was registered. And as usual, this action was taken against the petitioner that you have not verified the documents and accordingly loans have been sanctioned. They are not paying, bank has sustained pecuniary loss, this, that. My lord, though they have initiated proceeding against the petitioner, simultaneously, my lord, dispute cases were registered against the loanees. And most interesting part is against the persons whom my lord these cases were registered, they started paying. And they paid. Almost all the loans they have paid in the meantime. So, well, this has...
You might have persuaded
No,
to pay.
because I was suspended. But the bank
You might have said that
Yes,
you are
yes,
not paying,
you-
therefore I am in soup.
I am in
pay.
shop and I was suspended. Now, my lord, I lost my job, everything. But all the cases, bank succeeded in getting the money. In some cases, entire amount has been paid. In some cases, they are paying installments regularly. So when the situation has changed in this way, petitioner filed an application that under this situation, why I will suffer. Court said, no, I cannot consider all these things. Though the documents might be public documents, but I cannot consider all these things. This is the case. In short, this is the case.
Technically, the trial court is correct.
But a 2005 DN Paddy's case, perhaps there are documents which is not part of the records, cannot be considered at the stage of charge. That decision has been diluted. But to what extent it has been diluted? Well, this may be taken up on Monday or Tuesday. I will.
Why have you not filed a 482?
482 I had filed.
Why have you got it converted to?
Court said no, at the stage of charge, you have to file revision.
No. 482
I
would have been a
insisted.
wider
I insisted.
jurisdiction where,
My lord may see.
and the 482 can consider the
Five
document.
of my cases.
I have seen that proceeding, therefore I am asking.
Five of my cases have been transferred. It will be listed here again. I said time is not there. No, it will be automatically converted by the office.
So in the 482 proceeding, the document could have been considered.
My lord.
And some order could have been passed. But in a revisional jurisdiction, to what extent the court can exercise?
Let it be on 6th or 7th. Let's see.
7th. But somebody was arguing yesterday, and I kept it for a couple of days thereafter to Khana. When is that matter?
On this point.
Exactly same point. He says that when the loan amount is paid back, offense is washed out. That's what he was saying.
Well, what is there, but
because there is no loss to the extent.
I'm not on the case. Nowadays, what is happening, Ballard? The time when our classmates were joined in banks, situation was different. Now, banking system.
Bank job is much more dangerous now.
Yes, they are doing aggressive things. You have to achieve this target within this period. And if by any means they have achieved, they will be felicited like anything by conducting a meeting, giving bouquet, this, that.
If the money is not paid back, then you are a criminal.
You are a criminal.
That's what is happening. Banking is very difficult now. Bank job is much more dangerous than any other.
Any job nowadays.
And you retire thereafter, there are many FIRs.
It is happening.
This is what is the.
If your lordship permits, my lord, may I submit one thing, my lord? I was in Justice R.K. Patra's courts, my lords. And in particular matters, my lord, the branch manager of Paradip branch, my lords, he granted particular loans beyond his limitation, but that inures to the benefit of the bank. Bank gained huge amount of profits, but the bank management went to Supreme Courts, and there were in which that SLP, the Honorable Justice R.K. Patra judgment was quashed. It came up at the Times of India. I had opportunity to talk with Justice Patra in the chambers that he did something for which the bank was benefited, but that was viewed adversely. The branch manager went to Supreme Court. Supreme Court set aside Justice R.K. Patra judgment.
The bank is also doing business.
Yeah, they have been. Yeah, this is commercial establishment. In fact, they are all to earn money, my lords. This is one kind of. Anyway, my lords, I agree with you, but his complicity is in different way, my lords. On the next stage,
okay, we'll see. Okay, 6, 7. Okay. 7.
Question of NBW.
NBW.
My lord.
August 3. Okay. When was the NBW?
NBW was pardon.
28. 2023.
2023, my lord. But liberty given by this honorable court earlier, my lord. But he did not surrender, and thereafter NBW has been passed.
What? Where is that liberty?
My lord.
It's some medical problem.
Yes, sir. Medical problem.
Medical problem.
1 year.
A petitioner is assailing the order dated 2/8/2023, passed by elected HTJM Rairangpur in CT case number 755 of 2021, whereby NBW has been issued against him. The counsel for the petitioner submits that due to his medical due to his health issues, he could not appear before the court. Therefore, the NBW has been issued. And he undertakes before this court on instruction that the client would appear before the surrender before the court below on or before the 30th of August. Subject to petitioner surrendering or appearing before the court on or before 30th so and so, and awaiting the remedy under law, the NBW is set aside with the cost of rupees 500 to take. Yes. Yes.
Item 8.
May it please your lordship. My lordship, I am appearing on VC, my lord. I may be pardoned, my lord.
Yes. Yes.
My lordship, I am appearing on behalf of Mr. A. Mahapatra. My lordship, the petitioner is custody since 31/1/2020,
Yes.
my lord. And the final form has been submitted on 8/2/2017. And meantime, there are some development has been raised, my lord. And we are trying to, there are many witnesses has been examined. So we are trying to get the certified copies, my lord. My lordship, may keep it to 2 weeks after or after 15th of August. Within that period of time, we will obtain the instructions.
What is the offense?
My lordship, I have not been informed regarding the offenses because I couldn't verify the exact amount and exact offenses, my lord.
It is 120B, 420 and 409. You are in custody since?
Yes, my lord. Since 31/1/2020.
2020.
Yes, my lord.
You are appearing, Mr. Dhir, you are appearing for?
Your Lordship, I am appearing on behalf of Mr. Sarthak Naik. Mr. Naik asked me to take a pass over, Your Lordship. Mr. Naik is on his legs in another court, Your Lordship.
He is asking for adjournment.
Yes. Yes.
Yes. Okay.
I'm much obliged, Your Lordship.
Yes.
May I please, my lord? Case is under section 302. The petitioner is a lady.
CD is already there?
My lord?
CD.
Yes, madam.
Yes.
The petitioner is custody since 22 January 2020.
2020.
My lord.
What is the case?
Some witnesses have been examined. And
My lord, main thing, it is a matter of 302, my lord. There are the 19 charge-sheeted witnesses are there. Only, my lord, 4 has been examined, my lord. Yet to be, there are the urgent and necessary witnesses are yet to be examined, my lord.
She is a lady.
Yes, my lord, lady. And
she is in custody since 4 years.
Yes, my lord.
What are the allegations?
My lord, the informant and eyewitness, the father of the deceased, my lord, he has not examined till date, my lord.
Informant has expired in the meantime.
And another, his mother.
Let's see what are the allegations.
Man, the facts of the case. Facts of the case is like this, my lord. On the date of alleged incident, there was disturbance in the family due to cooking. The other members of family members to ask the accused why she was cooking only rice and some vegetable materials. That's why there was a tussle between the family members.
The petitioner is a wife, my lord. And stabbed to her husband, my lord.
Okay.
And subsequently, the petitioner assaulted the deceased and the deceased succumbed to the injuries. No motive, no intention, and the due to sudden provocation, this as the account. Page 16, I have annexed the charge sheet, my lord.
How many children you have?
2 children.
What is your age?
My age is, my lord,
44.
44. Now 50. Local man, any stringent policy.
My lord, I
That's
think
right, but where will you stay to come out?
My lord, I may pardon.
Where will you stay? You come out. You have stabbed your husband and you
Yes.
can't come to your husband's house.
Some of the family members have also turned hostile. I have annexed them, given the documents. Now in matter has been.
my lord, my learned friend, those depositions has been filed here that belong to the date of 2022, my lord. Now it's 2024, man. Perhaps I think many more witnesses. have been-
Get some
exam-
evidence. What has come against?
My lord,
Because this is pending since 2023. I
2020.
think she is entitled to be.
she is 20.
She is entitled to be. You just
My lord,
2022 this matter is pending.
my lord, 2022 matter is pending.
Get some material. I'll put
My
it
lord,
today.
in the meantime, I have given the last time I was not there.
He is correct there. 2022 this petition was filed
Just
and it's pending.
My lord,
Now what had happened? You just
13 witnesses have been examined. Most
Yes,
of the
yes.
witnesses were
Now my friend is serving and the rest of a deposition copy. Let to another date and your lordship may pass.
highlight and file it.
I have given in the flag R.
Let
I have
counsel-
another copy I am giving.
1 minute. Let counsel for the petitioner submit that this petition was filed in the year 2022. And at that time, few of the witnesses were examined. Four witnesses were examined. And this application is pending since last 2 years. Meanwhile, other witnesses have already been examined. Few of the family members of the accused have also turned hostile. He wants to place on record the evidences for other witnesses. Within 2 days. They may be filed. He hands up for the evidence of PW1 to PW
13,
PW 13. PW 13. 13. The same maybe copy of the same may be supplied to to Mr. Rahul. Leaves the matter on Monday.
I already copy
But
shot.
you just highlight and give a slip. Who all are the witnesses have turned hostile,
My lord.
and what are the evidence which has come on record
Yes,
against
ma'am.
you?
Yes, madam.
I will record those things and I'll grant you bail.
Yes, madam. Let it come on.
She is entitled. See the lady. She stabbed the husband because of the way she was treated in the house,
Yes, madam.
and 4 years in custody.
Yes, madam.
You give this Monday.
But I copy already shot, madam.
File it. Yes.
Madam, I may pardon. Next week, 6th or 7th. As your lordship.
My lord already told 5.
5.
Yes.
7th.
5.
7th. 7th. Let it be
My
7th.
lord was told already 5.
Let it be 7th. Okay.
5.
No, let it come on 7th only. 7th is a good day. Yes.
Item 10.
But give some assistance, then only you will get.
Madam, I may pardon.
Give some assistance in the sense.
I will note
so
down.
that
Whose
it's a
witness have been
case of
turned hostile?
30 It's a case of 302. While granting bail, I have to give reasons.
Reasons.
So please give me the reasons.
Madam.
Okay.
Item 10.
Yes.
Memo for withdrawal.
10. Offense?
Offense 3 is 76(3), my lord.
376.
My lord.
Huh?
But petition is put below acquitted, my lord. Both the petition.
No, they recruited.
Yes, my lord. The copy also attached here.
Why this bill?
I am sending.
When they were recruited?
My lord, Which?
So, this petition is pending since. That's the reason nobody is coming.
Nothing is there, my lord, the memo for withdrawal, my lord.
Hmm?
Withdrawal memo is there.
Already there.
Yes.
Why are you showing it? Why are you showing? Oh, withdraw. Yes.
Item 11.
May I please your lordship on behalf of S. Das Mahapatra. Your lordship, as per the instruction that I have received, this bail application is infructuous.
Infructuous. Okay. Infructuous. Yes.
Item 12.
Both the way. Okay. Infructuous. Let it go.
Item 12 on behalf of Mr. Chand, my lord.
Submit that these present petitions are infructuous. Don't know. Is infructuous. Yes. Yes.
On behalf of Mr. Chand, my lord.
12. Item 12.
Item 12, my lord.
Yes.
My lord, this bail application was previously disposed of by Honorable Justice V. Nursing, my lord.
Where is that? Where is
Bail
that?
number 13067 of 2022, my lord.
13067.
67, my lord.
Yes, yes. So no, it has to go. Why it is? Tied up.
Earlier it was not by the other.
Yes. Tied up matter. Just see next. Yes, file it. So no panda. Tied up matter. Huh? Oh, order careful. Registered wrongly registered. It has to go before that. Yes. Tied up matter. This being a tied up matter, for this being a tied up matter, the same may be listed before the appropriate bench, subject to the permission of Honorable Chief Justice. Yes.
13.
Yes.
NDPS. 100 kg ganja was used from the car. Petitioner is the only person. Petitioner is the only person inside the car, and 100 kg ganja was used.
And the last time the matter was listed on 27/2/2024.
Right.
It is listed there. Before that also nobody appeared. Nobody is appearing. Thereafter it was said that leave this matter on such and such day, as spread by the land counsel for the petitioner. No further adjournment will be granted. Before that, nobody was appearing. Nobody was appearing.
Since 19/12/2023, this matter became adjourning by time.
Since in the present matter, nobody is appearing. Constantly, since in the present matter, nobody is appearing on behalf of the petitioner. When the matter was repeatedly listed before the court, it seems the petitioner is not interested to proceed with the same. Dismiss.
Item 14.
May I please, my lord, on behalf of Mr. S.K. Deep, kindly pass over.
Pass over.
Oblige, my lord.
Item 15.
Yes. What is this matter?
Charge sheet submitted under section 354A, 354B, 195A.
354B.
But my lord, here the serious allegation that the petitioner is the father, informant is the daughter. That the daughter has given a report that the present petitioner has committed a rape. For that reason, a case was pending. Again, my lord, the 395A was added because he threatened that the informant that would withdraw the case.
Is it 376?
376 earlier it was registered against the present petitioner. Doctor has given lost FIR.
No, this FIR is 376 or?
No, ma'am. This FIR is 354A, 354B, and 195B.
What about 376? What happened there?
That case is going on.
Going on.
Yes.
He is on bail.
Subsequently, he got bail.
But in this
Then
case,
after he is threatening to give false evidence.
in this case, he is in custody. In this case, he is in custody. Oh, adjourn karo September. Yes.
Item 16.
Yes. Permitted to withdraw. Yes.
17.
Yes. 70. What is this matter?
And 17 is 302,506.
What is the stage?
Madam?
What is the stage of trial?
The charge sheet has submitted. What is the stage of trial? On the last occasion, he has
When
told that-
when was the last when was the application rejected?
Trial court.
Trial court.
Rejected on 2/12/12.
Huh?
And I rejected on 2/12/22.
2/12? No.
No, sir, man. That
23/8 to 2023.
No, it's 31/8/23.
Huh?
31/8/23.
30.
Page 29.
Huh?
Page 20.
That is on.
The free copy of the order dated 31/8/20.
Right on. The petitioner is accused in FIR number so and so under section so and so. Okay. The petitioner's application for bail was turned down by the court, turned down by the third additional sessions at Baleshwar in ST case number 215 of 2023 on
31/8/2020.
31st
8.
31/8/2023.
Right.
23. Next one. None appear for the petitioner. Let counsel for the state submits that a trial has already proceeded in this matter. Proceeded in this matter. In view of the same, the petitioner, I am not inclined to entertain this petition. However, the petitioner is granted liberty to renew his prayer before the trial court. With this liberty, the petition is disposed of. Old matter, let him move application there. Yes.
Last occasion was stated that copy PW1, 2 copies there, but he has not.
In the 2023, and now we are in 24. Many about 1 year is left. Let him move application, fresh application. Yes.
Item 18.
Otherwise, this matters will be pending only.
Item 18, Lordship, I will take instruction.
Huh?
It's again 23 matter. I will take instruction next week only.
What instruction? When the
Rejection is, Lordship, August 23.
August
23.
1 year. You move fresh application. I am giving you relief. Move fresh application. That is better. Why to keep it? The counsel for the petitioner seeks to withdraw the petition to renew his prayer before the trial court because the bail plea was rejected by the trial court on
25th August 2023.
25th August 2023, and the present petition is pending since then. And pending since last about 1 year, and much has changed in between. Therefore, on the fresh ground, he would move to the court below for grant of bail. With this liberty, the petition is disposed of. You move whatever ground in between. Many additional ground would be there also.
Yes.
Yes.
Item 19.
May I please?
Yes.
376(3) is there and POCSO is there.
What is the stage?
Stage victim examination.
And the bail was rejected before or after?
Before marriage.
Before.
Right.
Now repeat. Now repeat.
He will not grant bail, madam. Since POCSO and 376(3), unless your lordship intervene, he will not grant bail.
But the
Deposition, your lordship will consider or
no, let you get the
no,
one opportunity.
No, but they have normally they have not granting bail.
Normally you don't.
My lord, the victim hostile, despite that bail was rejected. I filed. I have granted. Get bail extorted. Victim hostile.
Now it is being advised to all the district courts.
Honorable Chief Justice has said that your lordship will go.
See the
My lord, that they are not
doing, my lord. They are only rejecting and sending to High
No,
Court.
no, you have to trust the.
My lord, once a offense under section 6 and 376 there. So, my lord,
You are in custody since?
my lord, since 2020.
Then I will get complaint.
10/8/2023.
10/8/2020. Not even a year.
Yes, ma'am.
Hmm.
Your lordship,
Very
victim statement is sufficient to convict a person, my lord.
Yes.
But that must be corroborated by the evidence, my lord.
But victim statement you see.
My lord,
The purpose of bail.
my lord, your lordship, page
PW?
19(3).
PW?
PW3, my lord.
3.
Sorry, my lord. PW4, my lord.
4. Okay. Come to 4. Yes.
He's a
Let's
minor.
go to the school. Are you continuing the study? I left the. Can you show your eyes at here? You see, they will come. What is the age of this child?
13.
What do you want to show me?
My lord, your lordship,
Examination
on the same day, victim was examined. He has stated that, my lord, he has not changed his dress or anything, my lord. If your lordship can never answer the evidence of the doctor.
But she is very, she is telling very detailed.
Detail but in the cross-examination, your lordship, paragraph 5, my lord.
Did not give water.
I did not give water. We have one room and one mirror. I had some injury on my left knee. Again, say I had no such injury. I had shown my injury on the cheek to the doctor. I had not lost my consciousness. He has stated that after the act, my lord, he lost his consciousness, and at 1 p.m. his mother came, her mother came, and then he reported her, my lord. And my humble submission, my lord, if you go to the medical evidence, my lord,
Yes, medical, very good.
medical evidence, my lord, PW3, my lord, page 19. I have marked, my lord.
3.
My lord, PW3.
After how many days?
The same day, my lord. On same day, 9/8 is the affair, my lord, lordship. Same day, if they went to 1 p.m. to the police station, and
Yes, let's see medical.
There are two material witnesses there, madam. One is victim and her mother statement is there, madam. They have deposed their evidence before the trial court, and that both the evidence are corroborated to each other, madam.
That's right, but see the medical evidence.
Medical evidence also negative, madam.
Complete negative.
Madam.
And she says that there was no recent sign of symptom of sexual intercourse.
Yes, madam, that's there.
So very detailed she says that this has happened, that has happened.
Madam.
And if the medical, why a doctor will tell lie?
Yes, that is right. But so far the statements of the victim and
that's right.
mother is there,
That's right. But
corroborate each
medical
other.
for the that is for the purpose of conviction.
They are
Conviction
fully-
you can convict, but
They are
see,
fully supported the prosecution case. Both the victim and mother is also a eyewitness to the occurrence, madam.
but how will you deal with this?
if your lordship go
Medical
through the evidence of mother and victim.
What is your age?
My age, my lord, the dispute is, my lord, I am a neighbor. I am a
What
married.
is your age?
I am a married man. I am the neighbor of the victim. I am dealing with goat business now. He is the father of the victim has taken that.
And when your bail application was rejected
My lord.
by the trial court,
Hmm.
whether this medical evidence was there?
No, man.
No.
No.
Right on. The trial court has to consider this.
My lord.
Right on. The petitioner is agreed by the order dated. Order dated.
My lord.
Where is the rejection order?
My lord. Annexure
In the
2.
prayer, you don't write anything. That's the whole difficulty.
19th. Annexure 2, page 11.
Right.
Yeah, you have it.
Agreed by the order dated 16/9/2023, passed by additional sessions come special courts of Bokyo, Niagara in special GR case number 77 of 2023, whereby his bail application has been rejected. Petitioner is in custody since?
My lord. 10/8/2023. August, 10th August.
10th August 2023. The trial is proceeding that is the expected fish. Subsequent to the rejection of the bail application, the victim girl was examined by the court below on 6/11/2023. 2023. On the same day, the mother of the victim was also examined. On 7/11/2023, the doctor who examined the victim was also examined apart from the other witnesses. At the time of deciding the bail application, these testimony of these witnesses were not available to the trial court. Or let it, Mr. Tripathi, legal counsel for the petitioner, submits that the testimony of the victim and her mother is completely doubtful in view of the independent evidence of the doctor who has completely who has categorically stated that there was no symptom of any sexual intercourse found sexual intercourse, and that there was no injury to the body of the victim. In the light of the evidence of the doctor, he is entitled to bail. I am of the considered view that since these evidences were not available at the time of rejection of the bail applications by the trial court, the petitioner should approach the trial court afresh. And if such application is moved, the trial court should consider the entire evidence which has come on record, and decide the bail application afresh with this observation. Yes. Give it back.
I will pardon my lord. Item 15. I'm just.
Yeah. It didn't come.
I'm in another court. That's.
Oh, the urgent, then in the urgent day we'll do it. What is the big deal? We'll do it.
Tomorrow, my lord.
When it will be? Huh? September, you don't come see the
No,
pressure. You can't come at your pleasure, you know. There are many matters.
Another court I am.
Sir, you should have send some junior.
Mobile.
Short date. Yes.
Tomorrow, day after tomorrow.
No, short date. I can't tell tomorrow. See, try to please
Maybe
cooperate.
taken up after lunch, my lord.
No.
354 more than a year is in custody.
Then put it next week. Yeah? Next week. Yes. A bail matters at least give precedence. Otherwise, see, next week.
Your Lordship.
See what Tuesday.
Your Lordship, on behalf of Amalan Shaktipal, praying for Passover.
Yes, Passover.
May I please, my lord?
Yes.
My lord, I'm in custody since 27/6/23, my lord.
Yes.
And this is after a period of about 8 months, this matter has been taken up, my lord. And I lay stress on my lord I have filed one IA, my lord. And during the pendency of this case, my lord, the mother of the I would like to draw my lord's attention towards some of the medical documents of the mother who is suffering from one scanning report finds place, my lord. Is suffering from mild frontal cortical atrophy, my lord. And there are no male members to take her to hospital, my lord. And she's at present undergoing loss of speech, my lord, reasoning ability, and she cannot, she's difficult in speaking, my lord. And my lord, this is a totally, and I would like to draw my attention, my lord's attention towards annex of some of the ones, the statement of the victim, my lord, 164, my lord. That is, annexure 3, my lord. Page 15, my lord. Not even
What
a
is the
single.
state of the trial now?
My lord, out of 25 witnesses, 16 have been examined, and out of rest 9, 5 are IO, my lord. 5 investigating officers are pending to be examined, and 4 independent witnesses, my lord. And this matter was
after your bail application was rejected.
No, yes, my lord.
Thereafter, what had happened?
My lord,
Any
thereafter,
witnesses were examined?
yes, my lord. Some of the independent witnesses have been examined. About 4, my lord.
Have they supported the prosecution?
My lord, yes, my lord. Towards the last, about out of 16, 10 have not supported and 6 have supported, my lord. They have declined.
The person copy not sub, my lord.
My lord, at that time,
why don't you move a fresh application before the trial court?
My lord,
In the changing circumstances. See, this has been pending since last 1 year or so. Meanwhile, witnesses have already been examined. You repeat your application and immediately file here.
My lord, I will not be given a chance, my lord. I will not be granted bail there, my lord. And that is pending. This matter has come for the first time after 8 months here, first time. And my lord, the mother is suffering, my lord. When CT scan report
suffering is something different. It's a POXO case, you know.
My lord.
And my lord, that can't be a ground.
My lord, summons have been sent to this victim. She has not.
You are showing me 164.
Yes, my lord.
Where is that?
Page 15, my lord. Annexure 3.
Yes.
Shall I read? Yes, my lord.
Read.
Yes. ମୁଁ ଆଦିତ୍ୟ ଭୋଇ ରାଜେଶ ଭୋଇକୁ ଭଲ ପାଏ। ସେ ଆମ ଘର ପାଖରେ ଗୋଟିଏ ବିଲ୍ଡିଂ କାମ କରୁଥିଲା। ସେଇଠୁ ଆମ କଥାବାର୍ତ୍ତା ଆରମ୍ଭ ହେଲା। ଆମର ଫୋନରେ ମଧ୍ୟ କଥାବାର୍ତ୍ତା ବହୁତ ହୁଏ। ଆମେ ଦୁହେଁକୁ ବହୁତ ଭଲ ପାଉଥିଲୁ। ଗତ 14/6/23 ସନ୍ଧ୍ୟା 7ଟା ସମୟରେ ଆଦିତ୍ୟ ଗୋଟେ ମୋଟରସାଇକେଲରେ ଆମ ତେଲେଙ୍ଗା ସାହି ଛକକୁ ଆସି ମତେ ଫୋନ କରି ଡାକିଲା। ମୁଁ ମଧ୍ୟ ଆସିଲି। ମତେ ତାର ମୋଟରସାଇକେଲରେ ବସାଇ ପ୍ରଥମେ ଚାନ୍ଦବଲି ତାର ବଡ ବାପା ବିଜୟ ଭୋଇ ଘରକୁ ନେଇଗଲା। କିନ୍ତୁ ସେମାନେ ଆମକୁ ରଖିବା ପାଇଁ ରାଜି ନ ହେବାରୁ ଆମେ ପିରାଟ ତାର ଧରମ ଭଉଣୀ ଘରକୁ ଗଲୁ। ସେମାନେ ମଧ୍ୟ ରାଜି ହେଲେ ନାହିଁ। ତେଣୁ ଆମେ ଆଦିତ୍ୟର ନିଜ ଘରେ ରହିଲୁ। ମତେ ସେ ତାଙ୍କ ଗ୍ରାମ ଶିବ ମନ୍ଦିର ବିବାହ କରିଥିଲା। ସେଇ ବାହାଘର ତାର ଭାଇ ଟୁଟୁ ଓ ତାର ବଡ ମା ଅଖୁଜା ବାଇ ଥିଲେ। ସେବେଠାରୁ ଆମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହିସାବରେ ଥିଲୁ। This is the statement
of this girl?
My lord, as per the.
Yes.
What is your age? What is your age?
So my age is 22, sir. 22, my lord. This is the same statement given before the police, my lord. And there is not even.
Of course, victim silent with regard to the allegation of rape, my lord. But almost 15 witnesses have already been examined. Let me verify let them.
The 164, she is saying nothing.
Of course, my lord. That's there. 164 is silent with regard to the allegation of rape, my lord.
But the same is with.
Court was examined. In the court, she was examined.
Yes, my lord.
Victim. Where is her statement in the court?
I don't have it now, my lord.
It is examined.
Yes, she has been examined.
She has already been examined.
Yes, my lord.
Has she said anything about the
all examined statements? She has, no. exaggerated statements, not beyond what she has stated in the 161 and beyond what 164. That had been confronted, my lord.
Where is that testimony?
My lord, at the time of filing this case, my lord, that she was not examined. But thereafter, she has been examined.
Then you should go to trial court.
Still then, my lord, I don't
Trial court.
expect.
I will record it. See, in the 164 statement, she says nothing.
My lord, same is the statement
indication
before
of
the police,
evidence.
my lord. My lord, same is the statement before police 161. And my lord, I would like to draw your attention, my lord, towards the medical report annexure 4, my lord.
I'll just observe those things and I'll send you so that you can get the right.
My lord, what I would like to invite your attention towards annexure 4, my lord, that is the medical statement, medical report, my lord.
Yes, show me. Show
Page
me.
17,
What
my
is
lord.
that?
Annexure 4,
Yes.
page 17, my lord.
Yes. Yes.
There are no sign and symptoms of
No
recent
injury mark on the.
no recent sexual intercourse. No sign and symptoms of recent sexual intercourse, my lord.
What is there? What is there then? Yes.
My lord, any stringent condition, my lord.
In the medical evidence also there is nothing.
Let's serve a copy of deposition. Thereafter,
What deposition? There is in the medical report. It says that there is no sexual intercourse. In 164 statement, she doesn't say anything.
my lord.
And
My
then
lord,
where is the
my lord, with your due permission, one more document find place in the record, my lord. One more record. That is in the IA page 7, my lord. One RTI application, one information is sought under the RTI, my lord.
Oh, RTI, forget that.
My lord,
This
just
is
for your my lord, for
Yes.
the my lord's information, this mother, the victim of the mother, the informant is in frequent visiting terms to the accused at jail, my lord. Any stringent condition, my lord.
What do you say?
What's in my post conditions?
That's better idea. Better idea. There is right up. Petition is agreed by the order dated. When was it rejected? A petition is an accused in FIR number so and so under section so and so so and so. His bail application was turned down by the order dated. Where is that order?
17/10/23, my lord.
His bail application was rejected by the Court of Additional Sessions Judge cum Special Judge under POCSO in Bhadrak in special POCSO case number 56 up to 2023 on 17/10/2023. Learned counsel for the petitioner has taken me to the statement of the victim under 161 as well as 164 CRPC. In the 164 CR, in both the statement, she has stated that she was in a relationship with the accused. On the fateful day, she was taken by the accused in a motorcycle. Both of them went to the accused's uncle's place. Since they did not get a space to stay there, they came back to the house of the petitioner and stayed there. On the next day, they went to the temple and got married. In the marriage, the family member of the petitioners were also present. Perusal of the statement under section 161 and 164 CRPC indicates that the victim has not alleged, has not whispered about any sexual assault made by the petitioner. The counsel for the petitioner again drawn my attention to the medical evidence. The the doctor who examined the victim on 26/6/2023 inter alia as stated as under. ये पारा नहीं जो except for there is no from the medical evidence as well as the doctor has very categorically stated that there is no sign and symptom of recent sexual intercourse. However, there is a old healed. क्या लिखा है? Old healed tears. Tears or what?
Yes.
Old healed injuries. Injury found in the body of the victim. Victim. In view of the fact that there is no in view of the fact that there is no allegation of any sexual assault made by the petitioner to the victim in the statement recorded by the police under 161 CRPC and the statement recorded under 164 CRPC and the fact that the state statement corroborates with the statement of the evidence of corroborate with the medical evidence, the petitioner is entitled to the concession of bail. The petitioner is in custody since. You are in custody since
27/6/23. 27/6/23.
Therefore, the application is allowed. Petitioner shall be removed by the court in session with condition 18 section points. Allowed. Yes.
I love that.
Yes.
22 months permitted to withdraw my lord. You can devote it to move afresh after
Yes.
the development.
And counsel for the petitioner seeks to withdraw the present petition to repeat his application before the trial court. With this liberty, the petition is disposed of. 23. Yes. Offense? Just see what is the offense.
Contact madam, copy not served, madam.
Urgent, laptop, yes. 24. Urgent, good a week for a call. 2023 matter. Yes. 24. Yes. What is the offense?
376.
Stage of trial?
Hospital, charge sheeted on.
Stage of trial? August 2023, bail application rejected. What is happening in the trial?
Sir, counsel.
They're also the same thing. 17 years. You tell me what is the stage of trial?
Petitioner is not moving each case.
Huh?
It is a bail. It is a bail application. Let's see, petitioner is not moving each bail.
I know that this is a bail application, but he is in custody. The bail was rejected in August 2023. Thereafter, anything happened in the trial?
I have not got the instruction.
That instruction you would get.
Without your lordship's order, I will-
No, I need not, because you are the prosecutor. You are prosecuting someone. Otherwise, I will grant bail. If you don't say.
Your lordship, once your
From
lordship will-
tomorrow onwards, you should be ready with the status of the trial, because it is the prosecution who has to tell. You are prosecuting. You have to tell us what is the stage of the trial. If the accused doesn't come, Then if the trial is progressing and if after the rejection of the trial court bail application, if something has happened, you tell me.
Here it is, here bail application rejection. Given the files are at night manner. Not possible on our first time alert.
2020.
One opportunity given alert, then
See, 2023 matters are pending. Bail matters 2023 just imagine.
that is true, my lord, but it was
And you collect information that all the 2023 matter wherever whatever is pending, you get instruction and keep it ready with you. Otherwise, the matters will be pending like this only.
Whenever the petitioner comes appearing, they are, my lord, saying that.
This is what happened. 5-6 matters nobody gets.
We have to give 1 day time, 1 week time, my lord, for that.
Next week. To the learned counsel for the state submit that he would seek instruction regarding the stage of the trial. He told me regarding the stage of the trial, he will tell you next week. Stage of the trial. And I'm keeping it to 1 week thereafter. You just tell me the day when the bail application was rejected. Thereafter, what had happened? If new material has come or anything substantial has come.
He is asking for the bail. If it is, he is not proceeding.
You don't go by that. You are prosecuting. Somebody is in your,
no doubt.
somebody is in your custody. Somebody is in your custody. You are the state. You are the mighty state.
How far he will not ask for the bail?
No. You are the mighty state. You can't say that. You are the state. He is in your custody. It is your responsibility. You have to get 1 week.
He has not come before your lordship.
Huh?
He has come before your lordship.
That's right. He has come, but because you are putting him in custody. He has.
Once he has come in, he should move his way.
He has come because you are keeping him in custody.
He will not move.
I'm giving. Okay, it's all right. I'm giving 1 week time. Get instruction because these are the matters pending from 2023, 22, and all. Unless the court knows what is the stage of the trial. It might have happened that he is not interested to prosecute this application. Might be a situation. So therefore, you must
assist. Not given any stay to this proceeding. Here only he has asked for the bail. Proceeding must be continued at all these stages. But if up to how far he will not ask, no doubt proceeding will continue.
No, but no. It is the prosecutor who has to assist the court.
No, we have not come before a lordship asking for any order.
Maybe. You are prosecuting. You are prosecuting someone and somebody's liberty is involved. You are the state. You can't say that. You have to get inside. You have no option. You have to get because it is expected by the court that the prosecutor has to assist the court because it is the liberty of a citizen involved. So therefore you can't say that. You have to get it. Next, leave this week, next week. Get instruction in all the matters. What is the stage of the trial? Yes. Next, 24. 25. Yes. 25. The same. This learned counsel for the state shall seek instruction regarding the stage of trial. Please the matter. Leave this week. Coming week, next week.
Lordship, ask the registry to correct all these things.
Don't increase the work of the court.
If he is not interested for any proceeding, he continued here.
No. Don't make it a ego issue, sir. You have to assist the court.
No, I am not.
Why should the registry will do? Is it our job? You are prosecuting. We have to decide. Otherwise, I will allow all the bail application. I'll allow all the bail applications. You are keeping someone in the custody since last 2 years. You don't know what is the stage of the trial. What are you talking?
No,
you are the prosecutor.
We want to get all these things.
No, you have to tell us. You have to tell me. Otherwise, I'll allow all the bail without asking you. What is this ego issue? You have to get it. You are the prosecutor. Some citizen is in the custody. You are custody. How can you say that you will not get the instruction? What right you have to say that?
I will say that the lordship will.
No. You have to get. Nothing doing. Next week you have to get, or otherwise I'll allow recording your statement that the prosecutor is unable to assist the court. Therefore, I'm releasing the petitioner in the bail. That I'll write. I'll tell you.
We will take instruction on the.
Be ready with that. Don't make it ego issue. What is this? After all, the citizens' liberties are involved. Somebody is in the custody since last 1 year, 2 year, and there are many poor people. They may not be able to afford lawyer. Lawyer may not be coming for that reason because of fees is not there. But he has approached this court. The court has to address the issue. He is in your custody. Imagine a situation that a lawyer is engaged. The lawyer is not paid. The lawyer is not coming. He will languish in jail because there is no assistance. The prosecutor say that I will not assist. The lawyer will, for the reason known to him, he will not come. Then how the court will decide? It is always the assistance from the prosecutor is expected. You can't say no to it.
Definitely will take it.
You have to. You have to. There is no option. 1 week for a record. If you don't get instruction, then I'll record that and I'll pass the order according to. Yes. I'll just come. Within.
My lords.
Yes.
I will be permitted to withdraw. I'm filing the withdrawal.
Yes. Withdraw. Yes.
I'm deeply.
27. Pass over. Okay. 28. Yes, sir. Yes. 1 acre. Stage of trial? Leave this week, next week. All these men. 1 week chadi. Yes. Learn counsel for the state. Non-appease for the petitioner. Learn counsel for the state would seek instruction regarding the stage of the trial. Release the matter. Okay.
29. Kindly pass over on behalf of Mr. Patna.
Pass over.
30.
Yes.
Please, your lordship.
Yes.
Here on 10/7, the state was asked to take instructions. I am in custody since 14/4/2023, my lords. And a charge sheet has been filed on 10/10/2023 without the chemical report being on record. And
What
no
about
charge
his
has been
instruction?
framed.
Whether the driver and the owner of the vehicle who are present in the spot have been arrested or not?
Driver and owner of the vehicle.
On next week.
This was in July 2024.
This application is filed in November 2020.
Chemical examination report is there on record? Next week. Next week. The instruction pursuant to the order dated 10/7/2024 is awaited. Land counsel for the state seeks one more opportunity. Leave the matter.
And let him get criminal antecedents.
And the counsel for the state shall also obtain instruction regarding the criminal antecedents of the petitioner.
And also instruction at the time of lodging the FIR, he had 2 months pregnant. In 28, 23.
Here 2 months. Here 2 months pregnant.
He Bhim Singh. He's Bhim Singh.
Oh, okay.
Don't pregnant him.
ଅଲଗା ଫାଇଲ ଧରିଛେ କି ଦେଖୁନ ସେ ଫାଇଲର ସିଡି ଥିବ
Is there?
30.
29 is passed over.
13,035.
Yes.
CD ଟା ଅଛି କି ନାହିଁ ଟିକେ କୁହ?
Antecedent. Whether instruction has come or not, just see. There was an order for 10th of July. Whether the instruction has come. अच्छा ठीक है 32 31 कौन 32 yes sir 32 yes
Blood. Yes, sir. 302, my lord.
302
Yes, my lord.
you're in custody since
Custody, my lord. That is 13/12/2022, my lord.
13/4/2020
13/12, my lord.
13/12/2023
22,
22
my lord.
what is the stage
Stays, my lord, after charge, trial not commenced, my lord.
when charge was framed
That particular is not, my lord.
you have not filed anything see this bail application was rejected on 24th July 2023
My lord.
any development has taken place
My lord, after charge, nothing, my lord.
charge when charge was framed before or after of the rejection of the bail application 1 year left in between.
No, my lord. After this bail application, charge has framed, my lord.
Then you
Pendency
repeat,
of the bail application,
see,
charge.
you do one thing, you repeat the bill application and come. That's better idea.
My lord.
Okay. Land counsel for the petitioner, Mr. Party, land counsel for the petitioner seeks to withdraw this petition to repeat his bail application before the trial court because on 24/7/2023 his bail application was turned down by the court below and within this 1 year the trial might have been progressed. With this liberty, the petition is disposed of. If such application is moved, the same shall be considered on the basis of material available on record. Material available on record. Okay.
Hon'Ble.
Yes. Yes. 33.
May it please your lordship.
Yes.
Lordship, I am in custody since 21st September 2023.
21st September.
September 2023, lordship.
You are in custody, okay.
Lordship.
Yes.
Lordship, the allegation against me is that
Last occasion, he has moved for application for interim bail, and
That's
this
it.
Hon'Ble court directed to take instruction of the interim bail matter.
Right.
Last order, lordship, candidate.
Yes. I said on adopting instruction. Yes. Interim bail on what ground?
Under his wife was having certain gynecological issues, which he had said that interim bail. But lordship, here I will plead on the basis of merit.
Yes.
Lordship. Lordship. Allegation against
420, 294 and 506.
Yes, lordship.
Yes.
Yes, lordship. Allegation against me is that the wife of I have borrowed 7,45,000 rupees from the wife of the informant by virtue of one agreement.
Yeah, taken 7,45,000 to sell a truck, my lord.
Yes,
That was the agreement.
Yes.
But in the meantime, when he asked me, lord, he did not sell his truck. This is the total case, my lord.
Another thing is that,
agreement is available with me, along with that black cash, given a black check. That has not been presented before the bank.
Yes.
This is case.
Yes,
That is
sir.
the allegation.
Lordship.
And he is in custody since?
Acquisition of 2023.
On the day when he moved the.
Why do you need his custody now?
And on the day of.
Charge sheet filed? Charge sheet filed?
Charge sheet filed, then how is charge sheet filed?
Why do you need his custody?
And on 15/11/23, he has last.
No, this is not recovery proceeding. Why do you need his custody? All documentary evidences.
Yes, documentary.
All documentary evidence. You have collected all documents and filed the charge sheet.
Yes.
Why do you need him now?
15/11/23, madam.
Black check was here. Given to
That everything is you have seized.
Yes.
173(8) is open. Just check it up. Further investigation is open.
I am on behalf of informer. On the day when he moved the bail application before the learned court bill on 15/11/23, he called upon the informant to refund the amount, my lord, a place. And at that place, he threatened and abused and did not return, for which one another complaint case also filed against the relative of the petitioner, my lord. On the occasion when this honorable court, before Justice Madam Court, that directed to instruct when he refund the amount.
See,
But,
I'll tell you, these are not the recovery proceeding, first of all. Second, he has given blank check to you. You should have prosecuted him under 138(9) Act also. You didn't do that.
My lord,
And there is a agreement which has not been complied. You could have filed a specific performance suit, that also you haven't done. So you are using this proceeding to arm twist to recover your money. This is not recovery proceedings.
my money may be secured, my lord.
Money is, I can't help you because see, these are not the proceedings for recovery. If he has misused the concession of bail, then it will bail be cancelled. That is a different story.
During pendency of bail,
I can put some condition that he will not involve, he will not threaten and all. All these conditions I will put. And he'll appear. If you are still feeling threatened, then what I can do is I can tell him to appear before the IIC or IO for some time. And beyond that, you can't keep him in the custody for. And the prosecution says that he doesn't need any custodial interrogation or anything of that sort. Right now. The petitioner is then accused in the FIR number so and so. The allegation against the petitioner is so. The petitioner moved an application under section. Petitioner moved. Petitioner is in custody since.
21/9/2023.
21/9/2023. He moved an application for grant of bail, which has been turned down by the court below on 15/11/2023. Learned counsel for the petitioner submits that learned counsel for the state submits that charge sheet has already been filed on 18/5/2023. The case is primarily based on the documentary evidences, which has already been seized and the charge sheet has been filed. Petitioner is in custody for about so appears for informant and submits that 7,45,000 has been taken by the petitioner in lieu of selling of what? Truck. Selling of a truck. Neither he has returned the money nor the truck is registered in his name. Rather, on the contrary, he has issued blank checks to the petitioner. Blank checks to the petitioner. All the blank check, agreement, and other related documents have already been seized and form part of the charge sheet. No further custody is required after the charge sheet is being laid down by the prosecution. Therefore, I am of the conclusion.
My appearance and my submission may be noted, my lord, that he has threatened at the time of when the moving
counsel appearing for the informant submits that he has threatened where?
On the date of the moving of 16/11/23, man.
And the date of?
On the date when he moved the bail application for the
petitioner when
and he said that he will refund the amount.
Petitioner on
16/11/23.
16/11/2023 had threatened the informant
to withdraw the case.
Case for which a complaint has already been registered. Therefore, the informant appearance that once the petitioner would be released on bail, he would threaten the informant and also try to influence the witnesses. Therefore, he strongly opposes the grant of bail. Taking into consideration the period of custody and the nature of allegation, level against the petitioner, and the fact that the charge sheet has already been filed, petitioner is entitled to grant of bail. He shall be released on bail by the court in session with appropriate conditions, approved age fit and proper, and with further additional conditions. That 1, 2, 3, 4, petitioner shall not influence the petitioner shall in no manner whatsoever contact the informant. He shall not influence the witnesses. The petitioner shall appear before the IIC. IIC, which police station?
Hon'Ble PS.
Hon'Ble PS every month. On 7th day of every month for a period of 6 months. Any violation of any condition imposed by this court or the court below while enlarging the petition of the bail shall entail the cancellation of the bail, cancellation of the concession of bail granted to the petitioner. With this observation, the petition is allowed. Yes. Next. Next.
Let's say another. The bail application was moved on 15th November.
No.
He was in custody.
All right, you got the bail. How does it mean?
Deeply obliged.
Yes.
I don't know response.
34 on behalf of Mr. Chand, my lord. My lord, we have to actually file the counter response, my lord. We'll file it in 2 days, my lord.
Counter? What? Cancellation of bail. What counter?
We are for the opposite party number 2, my lord.
It's all right. What is the ground of cancellation?
My lord, 2 grounds, my lord. One, the relevant materials available on record has not been taken into consider in any manner whatsoever, even if the merit of the cases has not been considered. Only technically bail is granted. First. Secondly, my lord, after release, he has misutilized the liberty.
What is the misutilization?
Mr. My lord, 310, they're like 310 after releasing of.
No, show me when he was released on bail.
My lord.
Yes. Tell me.
He has been released on bail by the amateur.
He was released on 18/4/2022, my lord.
18/4/2022. Then
Thereafter,
FIR was lodged on
18/6/2022.
What was the allegation in that FIR?
Allegation, my lord, 41 to 94, 195A, 34 IPC.
Yes.
The petitioner also moved on application for cancellation of bail before the trial court, sessions court. That has been rejected.
Yes.
That, yeah. And the court below, my lord, taken so many decisions, my lord. Imran versus Mohammed.
Technically, only on the ground that bail application was granted, that during the investigation, he has not been arrested. Except this matter, there is no ground.
Whatever there is, the court has granted bail. Why should the High Court will interfere?
Annexure 5, my lord.
Categorically stated that relevant materials.
You want any condition to be imposed? Tell me.
Yes, my lord, your lordship may kindly impose a condition. I am requesting one thing, that let the trial be commenced. Till that, it has not been commenced.
Till date?
Trial has not yet been commenced. It will take more time. So, trial may be targeted. It is a old case, your lordship.
How many witnesses are there?
My lord.
Charge sheeted witness.
Charge sheeted
Six witnesses. 6.
I will observe that expeditiously. Right. Petitioner is the informant in the present case. You are informant. You are the informant.
No.
Petitioner is the informant in the PS case number so and so under section. And the opposite party number 2 is the accused. The opposite party number 2 was enlarged on bail by the order dated
18/4/2022.
18/4/2022. 2022. Thereafter, it appears that he was involved in another case registered in registered as Sadar PS case number 260 for 2022, registered on 18/6/2022. The Land Counsel for the petitioner submits that the concession of bail has
No, my lord. Thereafter, madam, this petitioner filed an
I
application.
know that now. That I'll write. The petitioner, Land Counsel for the petitioner submits that the concession of bail granted to the opposite party number 2 has been misused by him, and he is indulging in criminal cases. He also submits that on merit also, the petitioner doesn't deserve, the opposite party number 2 doesn't deserve the bail, doesn't deserve bail. Taking all these points, he moved an application before the court below seeking cancellation of the bail granted to the opposite party number 2 under section 439(2) CRPC. The learned trial court, by a detailed order dated 7/1/2023, rejected the said application. The petitioner is agreed by the said order and assails the same in the present petition. I am not inclined to entertain this petition because the trial court has considered all the grievances raised by the opposite, raised by the petitioner. At this stage, Land Counsel for the petitioner submits that the trial should be expedited. Needless to say that the expeditious disposal of the trial is a mandate under law. Hence, it is expected that the trial court should do well to see that the trial is concluded as expeditiously as possible. With this observation, the petition is disposed. Yes, next. Yes.
36.
It may please your lordship.
Yes.
The petitioners are seeking washing of the proceeding against them. The case has been registered on the FIR of OP at the instance of OP number 2. According to her, her marriage with one Vikas Sharma was solemnized on 29/6/2017, and while in her in-laws' house, she was subjected to cruelty and also for dowry demand. And thereafter, she came back to her father's house and lost an affair on 23/8/2021, almost 2 months thereafter. Whatever the allegations she has made the allegations against her husband Vikas Sharma. Rest of the accused persons, I mean, including the petitioners, the allegations are general, and there is no specific allegations against them that they have committed any overt act. And these all these petitioners are women. Petition number 4 is the widow mother-in-law. And petition number 1, 2, and 3, they are all sisters of the husband of the informant, and they are all married. In the meantime, charge sheet has been submitted and cognizance has been taken. And I have filed the charge sheet as well as the FIR and the statements recorded under section 161 CRPC.
What are the allegations against you? Show me. Charge sheet, where is the charge sheet?
Charge sheet is, that is annexure. Annexure 1.
Yes.
Annexure 1.
Show me the allegation.
Annexure 1 is the first it is FIR. If your lordship permit me, I can read out the FIR first.
Yes.
I, Srimati Rani Sharma, aged about 30 years, daughter of Subhash Sharma, wife of Mr. Vikas Sharma, residing at Satsang area, sector 22, FT Raurkela, PS Tangrapalli, Sundargarh, Odisha, reporting to you that my marriage was solemnized on 29th June 2017 at Satsang area, sector 22, Raurkela, 76927, Tangrapalli, Sundargarh, as per Hindu rites and customs with Vikas Sharma in presence of family members, relatives. As per the demand of Vikas Sharma and his family members, my parent and relatives have given a sum of rupees 7 lakhs in cash and gold and silver worth of rupees 3 lakhs and furniture and household accessories worth of rupees 5 lakh. A separate list of articles has been attached herewith, was given to Vikas Sharma and his family members.
You just read the relevant part where the allegations are there against you.
Actually, there is no specific allegations against us. Against us.
Charge sheet, do you have any?
Charge sheet, my lord.
Mother-in-law,
My
sister-in-law.
lord. My lord, I will read out from the charge sheet, my lord.
Yes.
On the day of joining matrimonial home, her mother-in-law forcibly taken total gold and silver jewelry from her. Her parents had given to her. When she was ill, her husband and her in-laws, all in-laws, were not providing him medicine and medical checkup. As the daughter health was deteriorated day by day, finally, she informed her father. Then her father taken back on 13/10/2019. And since he was resigning her parents at a Satsang area, sector 22, her husband and in-laws were not taking back to matrimonial home and demanding huge amount as dowry and
no in-laws doesn't mean that the entire family of in-laws.
I am going, my lord. Dowry.
Tell me the name of
threatening dire consequences if she and her family members not comply with demand. Hence, she reported the matter against her husband, mother-in-law Usha Kisran, sister-in-law Anju Sharma, sister-in-law Pinky Sharma, Jia Chaudhary, and sister-in-law Ruby Anethe Manuel, brother of law Prem Kumar, brother-in-law Sudham Chaudhary, brother-in-law Alexander Antony Manuel. Basing on this report, I registered. During course of investigation, I examined complaint, other witnesses recorded their 160 visited spot of the case is at a husband's house and a complainant such and such, West Bengal, situated at a distance of 344 kilometers. She had seized one joint photograph of a complainant with her husband time of marriage. On investigation, on one investigation card and list of dowry articles on a production of the present witness. I also issued CDMO.
Tell me whether these in-laws,
in-laws, my lord.
In-laws, the sister-in-laws are married.
My lord, they are
staying somewhere else.
My lord. Then my lord, read out the 161 statement of the inform, my lord. Relevant person, my lord. सुभाष शर्मा
मेरा नाम रानी शर्मा
आज
पेज नंबर
23 लिख रानी शर्मा
रानी शर्मा
हाँ लिखो आपके सामने दिया गया बयान है कि मेरे शादी 29/6/2007 खड़गपुर वेस्ट बंगाल के विकास शर्मा का साथ पूरी हिंदू रीति रिवाज के हम दोनों के पूरी परिवार से उपस्थिति में मेरे घर पे हुआ था और गंजू मार्केट के कम्युनिटी सेंटर के उसी दिन से रिसेप्शन पार्टी दिया था। शादी के विकास के परिवार वालों के डांस डिमांड्स अनुसार हम लोग ने मेरे ससुराल वालों को फर्नीचर के लिए 5 लाख सोना और चांदी गहन के लिए 3 लाख और डिमांड मनी 7 लाख दिए थे। शादी के बाद अपने ससुराल वाले के साथ रहने लगी। शादी के पहले हम पता था मेरे ससुराल में मेरे पति सास उषा किरण शर्मा रोहित के और अंजू शर्मा उनके प्रति प्रेम
all of them are staying
together पिंकी उनके पति सुदाम चौधरी रूबी एंड मानुएल
yes I read it
all the 3 sisters
and the husband are staying in the same house.
Man, that is the point. She was under the impression that her mother, her husband and his mother are only staying together.
Then
He
she discovered that
they are all staying jointly. So she has got, she is being aggrieved to stay in a joint
those
family.
things are not issue. Issue is she is
Actually,
taking
there is
she-
not a syllable in the statement of the informant while being examined under section 161 CRPC that all her ornaments or valuables were taken away by any of the petitioners. More
Charge has been
specifically,
framed.
But he can raise all these points.
Charge has been framed or not?
Only
Charge.
prime facie is there, my lord.
No, charge-
You move application and let the trial court look into it. Then counsel in the present petition.
only I have only moving for
entire-
the ladies accused persons.
Whatever, but
Actually,
you were there. I was
the-
just examining the fact that whether the married sister-in-laws are staying there or somewhere else. If they would have been staying somewhere else, I would have questioned it. But the fact remains, the three women are staying here. After being married also, they are staying in their this thing, and the husbands are also staying. It's a Garjamai. So therefore, that is the whole difficulty. That is the whole difficulty. So it's the trial court of only segregate.
And there is absolutely no witness corroborating the evidence of the statement of
at this stage,
the
how can you say all
Mother,
this?
father, also other
the witnesses
there.
examined. Their statements I have annexed, my lord.
Passing of a fire registered against them.
Enter proceeding, my lord.
Registered against them, LPS case number so and so. And consequential proceeding arising after. The petitioner number 1, petitioner number 1 to 3 are the sister-in-law of opposite party number 2, whereas petitioner number 4 is the mother-in-law. The Land Council for the petitioner submits that there are bald and omnibus allegations made against all the accused persons. Therefore, no case is made out against them. I have read out the statement. The trial court has already taken cognizance of the offences against all the accused persons. The petitioner is given liberty to move the trial court for any petitioner is given liberty to raise all these points before the trial court at the time of framing of charges. If such a plea are taken or urged, the trial court shall look into the same at the time of framing of charges. With this liberty, the petition is disposed of. Next.
Obliged, my lord.
Next.
Your Lordship, on behalf of S. Das Mahapatra, Your Lordship, because of different removal, Your Lordship, it will be
This matter is pending, madam.
They have not filed the requisite, madam.
2022 and criminal
Notice issued, my lord. They have not filed the requisite. For that reason,
I will dismiss it.
kindly, Your Lordship, kindly.
No, this is 2022. You don't
Kindly,
you
kindly.
can't take the court proceeding like this. I myself issued notice on April 2024. Requisite is not filed. Defects not cured.
Itself file the reports and also we will remove the defect. Your Lordship. Kindly,
Right,
kindly. One week.
notice was issued to the opposite party number 2 by order dated 30th April 2024. However, the requisites have not yet been filed. Apart from that, the defects pointed out by the registry has also not been cured. The petitioner is given last and final opportunity to cure the defect and file the requisite by tomorrow. In the event the same is not filed, the petition shall stand dismissed without reference to the court. If the defects are cured, the matter may be listed before the court on the next Tuesday. Next week. 38.
May I please, Your Lordship? My Lordship, on behalf of Mr. T.K. Sao, my Lordship, previously, this Honorable Court directed to issue a notice to the opposite party. We already issued the notice and we already filed the requisite also.
Service Commission.
Yes, they have already received. Extra copy not served.
Are you?
My lord, I am appealing for the opposite party, not for
You
informant.
tell, we are searching for.
In CRLMC number 1659 of 2023.
How many matters are there?
There are two matters.
Two matters.
Okay, service complete. In both the matters you are appearing on one matter?
No, only on 1659 2023. Madam.
1659.
Yes, madam.
You are for opposite party number?
4. The informant in this case.
4.
So, per matter 1659, they have not served the extra copy, for that reason, matter notice not issued. Extra copy not served. Second item, sub item.
Why are you doing all this thing?
My lordship,
3 months, 4 months, you are not filing extra copy and all.
my lordship, we will file an extra copy.
Right on. The notice was issued by this court by the order dated 2/5/2024. However, adequate requisites with the extra copy has not been filed by the petitioner. Therefore, this service of the notice could not be effected on the opposite parties, private opposite parties. One last and final opportunity granted to the petitioner to cure the defects and file the requisites by tomorrow. In the event the requisites are not filed and earlier order is not complied, the matter will stand dismissed without reference to the court. In the event the requisites are filed, the matter will be listed before court after 2 weeks. Okay. Yes. Last opportunity by tomorrow. If you don't do, it is automatically dismissed.
Saying that
My lordship, copy has already been solved on the last.
Whatever you.
there. If
Milord, name of the Informant's Counsel may be reflected in the cost title, madam. Mr. Chandi Prasad Sani and Associates.
Obvious, my lordship.
Yes. 39.
An IA for modification, my lords. Lordship disposed of the application by order dated 15/4/2020.
What modification?
Lords, in the order dated 15/4/23 at para 6, my lords. In place of the learned SDGM, it has been inadvertently, it has been typed as learned family court, my lords.
SDGM for no, correct. Allowed. Yes.
Great.
40 milord. 1 week time may be granted, milord. By mistake, requisites could not be filed.
Both cases, requisite has not been filed. This is preemptory order. Change. By tomorrow, if it is not done, stand dismissed.
Interim order to continue.
Stand dismissed. You don't file requisite and you.
Item 47 already requisite file, madam.
46 same, 48 same.
I'll come, sir.
48 minute same, requisition not filed.
I have some meeting, so that I'm going. I'll come. What is this matter?
Item 4 matter is a vigilance.
Yeah?
Item 4 vigilance matter.
Yes, Mr. Das, what is this matter? Cognizance. September court on APS for the petitioner, even after second call.
Section 2. That was rejected on the court for fixed dates notes.
I'll put it in September. Something will happen.
No, what I suggest, Lordship, turn to page 19 lots.
19.
Page 19, 19 lots.
Yes.
I'm placing the last three line. It is held that the petition filed to drop the proceeding against the accused petitioner has no merit to be considered. Accordingly, the petition dated 10/12/2021 stands rejected, put off on 25th May 2023 for consideration of charge. That petition will be provided with the opportunity to raise all those points at the time of framing of charge.
In his absence, why should I do? I'll put it in September. We'll see. None appear. There is no say, na?
No stay.
None appears. In the interest of justice, none appears even in the second call. In the interest of justice, September last week. By that time, the charge would have been framed. And
I will also see that. I should expedite.
Item 14.
May I please? The petitioner is in custody since 12/4/2022, my lord. Offense under section 302.
302.
Yes, ma'am.
Yes. What is the stage trial?
Stage, my lord, 12 witnesses have been examined out of 25, my lord. Out of 25.
When the bail was rejected?
It is on 29/5/23.
29/5/23. 1 year, by 1 year, much have changed now. Repeat it. Right on. And counsel for the petitioner submits that his bail application, his bail plea was rejected by the trial court by the order dated
Order 29/5/2023.
29/5/2023, which is impugning the present petition. Meanwhile, within this meanwhile 1 year has elapsed and the trial is proceeding. Therefore, he seeks liberty from this court to move a fresh application before the trial court. With this liberty, the present petition is disposed of. If such application is moved, same shall be considered on its own merit. Yes.
Okay.
Item 20.
May I be honest? The petitioner is in custody since 3/7/2023, my lord.
3/7/2023.
Yes, my lord.
1 year. Yes.
It's a case under section, my lord, where charge sheet has been submitted under section 294, 323, 341, 376D, 394, 427, 34 of IP.
Yes.
Here is the case, my lord, where, my lord, the informant along with his sir was moving in a motorcycle and they are attending call of nature in a lonely place. Thereafter, the three persons obstructed them and misbehaved them. This is the allegation. And my lord, thereafter, my lord, kindly have a glance to annexure 2, my lord, annexure 3, my lord, the medical report, my lord. The victim has refused for the medical examination. And meantime, my lord, the matter has been amicably settled between the victim and the present petitioner. And last occasion, my lord has called for a report regarding, I have filed a affidavit regarding, my lord, settlement, my lord. And last occasion, my lord has called for a report from the police. What is the development in the case?
When the bail application was rejected?
My lord.
By the trial court?
That is
when?
That was not rejected, my lord. My lord, 11/10/2020.
11/10/23.
11/12/23.
11/10.
11/10/23. It was rejected.
Yes.
Trial court rejected. And when you entered into the settlement, whatever you were saying?
My lord, the last call for a report, my lord. That was
report is something different. You tell me when.
My lord, last on 31/7/2024. Sorry, my lord. 10/7/2024. The opposite party has entered into appearance and the report was called from the police, my lord.
You tell me when you settled the dispute, according to you.
My lord. My lord, on 13/5/2024.
24.
Yeah.
Or the time when your bail application was rejected, this was not there. This development was not there.
Not there.
You move fresh application. Right on.
My lord, meantime, my lord.
Counsel for the petitioner submits that the petitioner's bail application was rejected by the court below by the order dated. Order dated 11/10/2023. He impugned the said order in the present petition. Consider the petitioner submits that meanwhile the party.
My lord, a report was called for, my lord, that
Forget about report. Why should we entertain all this?
Then my lord, that in 376D, how the settlement will
There
be
is
made?
no question of what they say
account-
settlement. What is the worth of that? Let the trial court consider it.
Yes, sir.
I don't know. Huh? Submit that. In the meantime, the informant has settled the dispute with the petitioner on
my lord, 13/5/2024.
13/5/2024.
My lord. Affidavit.
He has pointed out to the order dated 10/7/2024, whereby this court has directed the state to seek instruction in this regard. I am not inclined to interfere in this present petition. However, the liberty is granted to the petitioner to move the trial court afresh and apprise this fact. Apprise the fact of settlement, and the trial court should consider. Trial court shall consider the worth of the settlement while considering the plea of bail. And trial court shall also consider. What is the stage of trial?
My lord, meantime, my lord, out of 4 witnesses has been examined.
The trial court shall also consider the evidence which has already come on record within this. Meanwhile, while considering the bail with this observation petition. Yes. Next.
27.
Yes.
Sorry.
23rd May 2023. The application is the bail application was rejected.
First of he asked for password.
Password he asked. Wait, password. He may come. Yes. Yes.
29.
May I please, Your Honors?
Yes.
My lord, the case is under section 20B2C of the NDPS Act, my lord, and the petitioner is in jail custody since 1st October 2023. The petitioner age is only 18 years, my lord. 18 years. And allegation against the present petitioner.
Recovery, how much?
My lord, 88 kg. 88 kg, my lord. The petitioner was driving the car, and the contraband article has been seized from the dicky of the offending vehicle. And
how many accused are there?
only two solo accused, man.
Antecedent?
The petitioner no any criminal antecedent. No any criminal antecedent. And my humble submission is that, my lord, during blast seal Jimanama is defective, my lord. The total investigation of the investigation agency clearly reveals that they have prepared all the document in Exchange Police Station, my lord. As because, Your Lordship, the PR number has been mentioned in all the papers. My lord, oblige.
One accused.
Yes, my lord. Oblige, Your Lordship.
Yes.
41.
Forty-one.
Passing over experiment. Investigation going on.
Going on?
Yes, ma'am. Investigation going on, sir. Correct.
Notice was issued. Service complete. Opposite party number 1. Opposite party number 2. Complete. When the FIR was registered, FIR was registered 14/3/2023. Still investigation is going on.
My lord, 14/3/2023, my lord. FIR was registered, my lord.
But still investigation is going on since 1 year.
There is no further instruction.
That is the instruction on 19/7/23. On that day.
19/7 means today.
19/7/23.
23.
On that day, investigation was.
Obviously. What is the stage now? Non-counsel for the petitioners, non-APS for the petitioner. Yes. Yes. What is the stage of?
Last occasion, Honorable Court directed to State Council obtain instruction, my lord. Madam, this is a case dispute between the brother and sister. Brother and sister na case chalo amar kisi nahi. My respectful submission, very emergency. No,
investigation is complete or not?
Investigation not completed, madam.
That's the issue.
Investigation open, but opposite party number 3 is a son of the petitioner, my lord. Informator भणजा ए ताका भाई भणी को कली के चलछि चलिबो से आपुनी हम घर ना भणी कोन सत्य ने दे घर या भाई ये सर जाई परनी बाहर को आर ये होनी कोन कहले सेटा पासपोर्ट होनी कि तार क्लियरेंस मिलनी सीप रे दिया भाई दिस इज वेरी डिफिकल्ट but actually no
my lord why are you not concluding investigation?
my lord as per instruction, my lord, the letter has as per tracking report, my lord, item has been already been delivered to the OP3. OP3, I think. I'm a petitioner 3. OP2 होची देवेंद्र माने भाई ब्रदर OP2 मैंने accused होची sister भाई आसुची
you are for petitioners na?
I am petitioner, my lord.
First, still investigation is going on. You tell me how much time will you take?
Only, my lord, my respectful submission, sir, भाई भौणी को बेटे चालू nothing. No course पे against petitioner 3 नसे बदल सीप रे जाई पनी का चाकी जाऊ पुलिस को एक्सीडेंट अछि क्लियरेंस मिलुनी देखु this is the problem.
Have you applied for bail?
नहीं बेल ता सहित हमर किछि कनेक्शन नहीं तो 41 नहीं जीव किछि नहीं से my lord होती ना केस थिले क्लियरेंस दोनाथि
That I can't help you.
से सीप जाई पनी कि पासपोर्ट पाउनी my lord.
That I can't help you because you are involved in the case. Then the only thing is I can.
Nobel job तार पड़ जाउछि ना भाई भौणी को करले.
That's right, but you are
allegation कोन भाई भौणी को सोचा भौणी भाई को सोचा. This is allegation.
Let it be taken up next week. In the meantime, I'll take instruction. What is the stage of trial and what is the role of specific role?
ना ट्रायल करो चार्जशीट तो सबमिट हेई नहीं दिस इज माय इंस्ट्रक्शन हो but my resolution is only no coercive action against the petition.
Quashing, you have filed a petition for quashing. You make out a case. Investigation is going on. How can I quash like this?
ना quash करियो कोनी नो खाली no coercive action against the petition number 3 से जीव तो भाई चाकरी बाकरी बंचियो सब आर कोन कि एलिगेशन अछि तन ये ओनली रिलेशन विल तांगा पुओ को फसै देले माने कम्प्रोमाइज कर देबे दिस इज अ केस
what is your petition you just see?
Case 14, my lord, that is the FIR.
नहीं हेरा होती हेरा हमर एफआईआर होती हेरा होती एफआईआर होती
What have you asked in the petition?
petition the man prayer to quash the affair and I also no coercive action against the petition.
Why he is praying for petition number 3? Because there is specific allegation against the petition.
I know.
Petition that day is absent. Se nathila se mamu sodio my respect to some mamu gali goch karibo respected logo boys alani mamu kara 80 na 50.
These things are not the test for the purpose of quashing.
Inherent power in authority.
Inherent doesn't mean that investigation is going on. I'll quash everything.
I am not interfering with investigation.
The only thing what I can do for you is I can insist them to conclude the investigation. Beyond that, I can't do anything.
Investigation conclude sir I am no case ta baijo mu jai pele tan mo life ta kono mai jauchi na mu bahar ku jai
I understand. Then see after charge sheet is filed, if you can make out a case on merit, it can be quashed also.
Yes, my lord, your lordship is saying in favor of charge sheet hele bi to mo case ta rahila na mu au kichi pai
Without fail within 1 week. I am putting it on Monday.
Yes, my lord.
You tell me why charge sheet is not filed, how much time will you take?
Bas
Yes, my lord.
Because ultimately the career of this young man is involved.
Yes.
You can't register a case and wait for
10 years
eternity to file the charge sheet.
medical ground ছুটি নেଉଛି না ମୁଁ terminate ହେଇସାରନି
Okay, let us see. 1 week wait. Let us see. What best could be done.
my lord.
Yes.
Extremely sorry. Item 27. First of all, your lordship,
Urgent.
lordship, paying for Monday, your lordship.
Passover,
Monday, your lordship. I am not seeking for.
Why you asking for Passover? You
ନା ଫାଇଲ ଟା ମୁଁ ପାଉନି ବୋଲି ମୁଁ କହିଥିଲି କିନ୍ତୁ ଫାଇଲ ଟା despite my serious efforts could not be traced up.
next week.
Next week Monday lordship
Monday, no, next week.
Yes. Okay.
I can't adjust my board according to your
Lordship, please, yes.
because so many matters. Since bail petitions are pending since 2022. Just imagine.
Lordship, next week lordship.
Yes.
Obliged.
My lord, on behalf of Mr. Sujit Mahapatra, my lord, in our church.
Is there? Is there? Yes.
Only, my lord, limited given modification of order.
What? Which order?
Order dated 6/2/2024.
What modification?
My lord, in this case, charge has not been framed, but charge has been framed and reflected in the order set.
You might have said that, therefore I have written.
No, no, my lord.
The petitioner seeks to withdraw this petition to challenge the order.
By the Lord and Sessions Bhadrak, and the charge has been framed, has not been framed till yet. Date is fixing to 5/8/2024 for framing of charge.
Charge has not been framed.
My lord.
Then after the charge will be framed, you file revision. Right. Oh, there is a by way of modification application, petitioners seek attention of this court regarding a typo which has occurred in the order dated 6/2/2024, where it is found mentioned that charge has been framed.
Correction of charge has not been framed.
Yes, in fact, charge has not been framed as yet. Therefore, he seeks modification. So, modified para one.
My lord, in this case, so in this case, what happens, my lord? But actually, what happens to 239 prisoners filed before the Lord court, my lord. Thereafter, it was
Whatever he has withdrawn, I can't, in his modification application, you can't raise anything.
Yes, my lord.
Wrong, right, whatever. Yes, next.
What is the
Yes.
This is a case
Yes.
for quashing of the entire proceedings against the petitioner. As it is under section 3 of the Epidemic Act, my lords, the trial is to be completed within 1 year. It has not been completed, so that goes. The rest is, my lords, the prosecution's. He's a software engineer, my lords. Now, during the first phase of the pandemic, my lords, he had gone to a nearby medical shop to get some medicine for his mother. And he had gone on a moped, my lords, scooty. So he had gone there, and while he was coming back, he was without a helmet and without a mask. Those are all, my lords, fines can be imposed. Now, while he was coming back, suddenly the police detected him, and the story is, he was trying to flee, so we caught hold of him and he fell down. This is the story written in the charge sheet itself. He fell down. And so when he got up, he abused them. So he abused them. And he was bleeding profusely after that, after he fell down. And well, he's a software engineer. 353, he has never tried to stop, if your lordship sees.
Charge sheet filed under which provision now?
353, सब लोग इधर
53, 188, 3 Epidemic Disease Act,
Disease Act.
77 M here.
Why are you after the young people?
And he's a software.
Find out some way out to close it. Software engineer without helmet, he was going and something happened. Young people, you work. See, they're not criminals. Please don't make them, they're in the threshold of their career. You can't spoil their life.
He's working.
Only the ego of some police. I stopped, you didn't stop, so therefore I'll thrust a case against you. This is
and my lord, he catches hold of him and he falls down and he starts bleeding.
That police personnel, both are injured. Police personnel.
All right.
Both are injured. And my lord,
No, police has not been injured.
Show me the medical of the police.
My lord.
Rider and pillion, again, brief facts of the case re dekhiye.
Of the charge sheet.
My lords, before that is.
He was released on 41A notice.
No, that is okay. No, but my lords, he is working in Accenture. So, my lords, he has to travel abroad. His passport is being held up because of this pendency of this case. And obviously, my lords, it was during the pandemic period. People wanted to avoid people also. My lords, here I'll just read out if your lordship says.
How to get out of the technicality? To quash, I have to be satisfied on merit to.
Yes, my lords. 353 is it applicable first thing. I have not prevented any public servant from discharging his public duty.
Charge has been framed.
Charge has been framed. No, charges have not been framed. Sorry. Charge sheet has been filed. If your lordship will see the allegation against me, says FIR. Malad, I'm just placing one paragraph. On 22/4/2020 at 12:10 p.m.
Where are you reading?
FIR. At running.
Page 10.
At page 10.
Okay. 10, yes.
Lordship gets a para 12. FIR. On 22/4/2020 at 12:10 p.m., Shri Kamal Sabar, son of a Gunpur of Madhupatna PS, Cuttack, UPD, reporting in writing that today, so he has reported, the police officer, on 22/4/2020 at 10 a.m., while he along with MM Biswal, C such and such, of 6th OSAP were performing patrolling duty at Press Chak. He had tried to detain one person on a scooty bearing registration number OD05AG4548, having no mask in his face and helmet, coming from Press Chak. But the said scooty rider did not respond and tried to flee forcibly. As a result, he along with the scooty rider slipped on the road. He fell. The accused, the scooty rider, slipped on the road and they both received bleeding injury on their person. On asking his identity, he disclosed his name as Priyaranjan Naik and also abused them in filthy language. He just added also abused them. Well, yes,
Except this last word, abuse them in slang language. What is the offense?
Charge sheet also might not be written that. Only he used that slang language. And epidemic act is inserted because
what is your story? They were going in a scooter without helmet, without mask. And police saw them. Out of they got scared. They were going back, they're turning back and going. They slipped and they fell and they injured injuries. At that time, police reached, and police only one word you said added, abuse them in filthy language. That's all. This is the offense.
And my charge sheet submitted under section 353.
You file whatever. There is nothing. Where is the charge sheet?
Charge sheet is.
Where is the charge sheet? Have you filed the charge sheet?
Charge sheet might have copy.
Copy.
Charge sheet copy.
Show me what is the investigation.
Same thing has been reiterated in the charge sheet.
Now,
See it. This is at page para 16, brief facts of the case.
You do one thing, you file it.
Yes.
I'll take it at Monday. I'll quash it. See, career of a young boy, why are you spoiling the career of this?
Along with the
There is nothing basically.
And they tried to prevent them from performing the duty. And just one line slang word.
What is the age of this boy?
The age is, my lords,
38.
38.
Working unnecessarily.
Politics happened due to Corona.
Corona time this happens. Everybody is scared.
The stress level is high.
Stress level.
Stress level high. Everybody was scared,
Most of them also lost somebody else in some of them.
So let us take a lenient view.
My lords. And
place the charge sheet on record.
And
so that without charge sheet I can't.
certainly, my lords.
And I think you have asked for quashing of what? FIR.
FIR itself. And section 3 contemplates that the entire proceeding is to be over within 1 year. Section 3 of the Epidemic Act. 1 year has gone by. So that goes
That goes.
automatically.
Only the other part. The other, nothing is made out.
Nothing is
From
made
the
out.
on
And he
merit.
works in Accenture. He can't get his passport. He can't travel anywhere.
Yes.
This is his.
You place it on record.
I'll place that.
I'll put it on Friday.
Anything.
Friday.
Anything
This Friday.
convenient.
File tomorrow. Tomorrow. Yes.
Obliged. Well, another thing, 73, your lordships had fixed up at 3 o'clock. Since there is a, no, since there is a, reference.
I'll just see you. I'll adjust in.
Yes, ma'am.
Yes.
Obliged. Some short date, Malad, already.
What?
Malad.
Yes.
Obliged.
My lord, the person challenged the order that at 25/8/2023 passed by Lord JMFC Hattori, my lord. The prayer for the further investigation of the case and add the under section 307 Indian Penal Code, my lord. My lord, charge sheet filed on dated 30.
You are agreed by that order 173(8).
Once in the note 173(8). Let's see. Charge sheet filed on section 341, 294, 323, 354, 506, 54, 48, and 34 of IPC, my lord. Let's we can see page 43, my lord.
Yes. 43, yes.
43. Peruse the case record, second para, peruse the case record as well as the petition. The present petition is filed by the learned APP on behalf of the informant, my lord. I am filing the petition, the informant, my lord.
You are the informant.
Yes, my lord. The petition filed.
Why are you agreed 173 further investigation? You should be happy.
No proper and fair investigation of the IO, my lord. Let's say that read, my lord. The APP on behalf of the informant ground that there was an allegation assault by the accused person by means of the crowbar, but no crowbar was seized by the IO, my lord. Though the injury report submitted of Dr. S.S. Pradhan, medical officer, CHC Salina, and also learned appellant alleged that injury is grievous in nature, and it may cause death in ordinary course of nature, and the siege of injury 4-inch x half inch of temporary relation of the injured. What the doctor was given. Then reject the my petition, the learned APP petition 173(8) in no power the magistrate, my lord.
Operating part.
Yes.
After careful scrutiny of 46.
Yes, my lord.
Of the case record along with the petition. Cognizance has already been taken.
Yes, ma'am. Careful scrutiny of the case, and APP is the case, GR case, and so registered Nadipada police station under section 41 and CRP served each accused person on dated.
My lord, actually operative part is page 47.
47. Second para.
After consideration.
Yes, ma'am.
Actually, my lord, magistrate has no power to give a direction for re-investigation. Further investigation is, my lord, he can pass order for further investigation. But re-investigation, the magistrate has no power. And my lord, whether the 307 will be added or not, it will be decided at the time of taking the evidence in the time of trial. Because court has power to alter the charge.
Yes, my lord is the discretion power of the my lord. Law is the principle of the basic body. It is approved and applied the state administration of justice and social justice. My lord is the to do justice. 170. No, under section 173(8) of a CRPC, no power of the magistrate. The further inquiry, the matter. By the my lord is the power 173(8). The CRPC any decision, my lord. Let's show the decision, produce the decision next week. We can fix the my lord.
What other evidence you are expecting to come on record? See, the medical evidence has come on record.
Yes, my lord.
And witnesses have already deposed. What else you want?
Record
173. What else you want? You tell me.
Injury.
What are you? Suppose I'll allow it. Suppose I'll allow it.
Yes, ma'am.
What do you expect that? What else? What other material the police can collect? You can't collect. Obviously, you can't collect. The police has to collect. What else police can collect? See, the injured was beaten up.
Yes.
He was medically examined. Medical evidences are there. 161 statements are there, and everything is there. What else you are expecting?
And APP, the APP is the fight the case. This is the APP, my lord. That is the government advocate, my lord. The Lord Court bill is the government advocate, my lord.
CRPC under section 302, you can assist the APP only,
Yes,
being
sir.
an informant.
Yes,
Okay.
sir.
You have rightly moved the application through APP. And the trial court has rightly rejected the application, saying that everything is over, cognizance is taken. And the charge says you go and argue, it is a charge should be 307, not 323 or
Fair
something.
and proper investigation.
What do you tell me on proper investigation? What do you expect?
Let's see the
What evidence you are expecting which is not collected by the police?
to produce the evidence, my lord.
What evidence extra?
Lords, kindly see page, my lord.
Whatever possible evidence are there, the police has already collected. What else you tell me? If something is left, then we can think of. According to you, what are the other evidence could have been collected by the police, which the police didn't do? You tell me.
Just say the police, my lord.
Again, you are saying
ମୁଁ ତ କହୁଛି କାରଣ ମୋର ଇଞ୍ଜୁରି ହେଇଛି ମତେ ବି କୋର ବାର୍ କୁ ସିଜ୍
injury ଆପଣଙ୍କର ହେଇଛି injury
yes my lord
ଡକ୍ଟର ପାଖରେ ଏକ୍ସାମିନ କରାଇଛନ୍ତି
ତୋର ତ simple
ଡକ୍ଟର ଦେଇଛି ଏଭିଡେନ୍ସ ମେଡିକାଲ ରିପୋର୍ଟ ଫାଇଲ ହେଇଛି ଆଉ କଣ କରିବେ 302 କରିଦେବେ
323 କଲେ
323 you at the stage of charge you argue and say that medical evidence says that it is a grievous hurt, so therefore there was an intention of killing me, so therefore it should be 307.
report is the simple
Then,
simple report is the simple fact, yes my lord.
then 326 is also not made out, 307 is also not made out. What to do?
ମୁଁ ତ ସେ 307 ଆଡ୍ କରିବା ପାଇଁ ପ୍ରେୟାର କରୁଛି ମୁଁ ତ
କହିଦେଲେ କେମିତି ହେବ ଆଜ୍ଞା ଏଭିଡେନ୍ସ ତ ଆସିବାର ଅଛି ନା
but let's be directed
My lord, his petition page 33, my lord, kindly see for a moment.
only the doctor can come and tell you whether it is grievous or simple.
No, he has given
he
that
has given how
simple
much-
age.
what
My lord,
to do.
33 is petition, my lord, kindly see. Only para 1 and 2.
You better you argue you withdraw this and argue all these points at the stage of charge. I will
say petition 173 8 ରେ ଦେଇଛି ସେଇଟା ମାନେ my lord ସେଇଟା ମୁଁ କହୁନି what my lord directed to complete the trial 6 witnesses
not complete the trial. The charge has yet not been framed.
No.
So you argue all these points at the stage of framing of charges.
Yes.
Right on. Then counsel for the petitioner seeks to withdraw this petition to raise all these points and urge before the trial court at the stage of framing of charges. If the petitioner urge all the points before the trial court, it is expected that the trial court shall take into consideration all the points raised by the present petitioner and appropriately pass the order for
At appropriate
at the time of framing of charges.
Yes, please.
Let him argue.
45.
Service देखो requisites file ना service complete. What is this case? For causing?
311 petition was rejected.
Find out subsequent manner directly to interpret that make this appeal party informant as a appeal party and says also that for a personal appearance says also after the report is not engaged any advocate.
POCSO.
Yes.
The allegation is that they have solved law relationship and taking law that advantage they have kept the relationship. Thereafter marriage has also solo marriage before the register. They lead a happy control.
Before the statement was made or after the statement? Before marriage. Then after marriage also she went to the court and gave evidence again.
It was before marriage was after.
When the statement she gave the statement in the court against you, you had no option, either marry or go to jail. So therefore,
they also bless with child and with that particular part taken into that aspect in Maladas also the one time hearing this postco matter whether who was possible or not. So that's why Maladas directed the state to take the instruction that in possible parties presence and the parties has also appeared, but here she is not engaged in advocate.
But can you assist me in this aspect? if full opportunity was given and cross-examination, everything is happened, you move 311. And you say that some development has taken place. So ultimately your object is to bring that witness to resile out of the earlier statement. That's the only object, and which is reflecting from pleading also. In that, in the face of those things, can the court allow?
In such a case, because from the very beginning, it is the case of the prosecution, which has been advanced through the FIR and the statement and including the deposition also, that it is the petitioner who has applied force for the purpose of kidnapping. It is the petitioner who has applied force for the purpose of having physical relationship. It is the petitioner who has persuaded with various means, and because of this pressure or the force applied by the present petitioner, things has happened. Which has been alleged to be rape or when alleged to be kidnap or subsequent
Whatever.
offenses under the POSCO is abusive. So my humble submission, since there are two things has been come up to this stage, that she has merit. So merit can also take a judicial notice because of the fact that after this all such things was over, because had there been in fact there was something allegation is there, then this marriage which has come out with a happy ending, the conflicts of happy ending.
Happy ending for the time being.
Happy ending for the timing because they will bless with the child and
It's not ending, because you know once I am going to be convicted, so therefore it is the marriage is a convenience. So the life of the girl may be jeopardized. That is the idea.
So in such a case, my humble reply to my story is that yes, of course, unless and until the girl will come to the doctor, unless and until things will come to the concerned court, and the girl will say that yes, it is court or it is portion, it is state, it is assurance, and because of the fact that the prisoner being scared off for the conviction, he has approached me for this particular purpose. But my not just think the other side. If the girl will come to the doc and she will say that no, it was although that the things is there because of my relationship I have married her, then I do consider marriage is right to be said.
Then where how will you throw the 164 statement? How will you throw the
No, my humble submission, I am interested in development because the fact that it's
I understand it is a catch 22 situation. If you do it is problem, if you don't do it is problem.
exactly the things.
Because if you see the life of these young people, if you don't do it, then you are doing injustice. Thinking if you do it is against law. What to do?
As per the entire case, both of them fled away, went from place to place.
Find out some judgment to strengthen the reasoning, so that at least there are many cases which are coming. 311 applications are moved because there is no option. If the girl has already deposed, unless the girl goes and tells that the whatever I have deposed is wrong, bound to be convicted and 10 years sentence. Gone, life is gone.
This law, my lord, saying the predicate of the boys. I do consider that the petitioner has done something related to the relationship, but it is not one-sided. It is also not.
No, you lost the train also. 482 also you can't file today because evidence has already come in record.
All parties there.
So therefore, your only option is you move 311, bring that girl. If she
I have filed.
see,
I have filed.
that's the only option.
I have also filed. I also filed 311 petition that is also been filed by the concerned court. That's why
That's the only option I'm saying. That at this situation, that's the only option. You allow it is a problem. No, don't allow there is another problem.
And court below has taken care of this. That in this situation you cannot allow 311.
That's right. Legally it is not permissible.
Not permissible.
But if you find out some judgment, it will be helpful. I'll put it next week. Because there are many matters are coming up this way. You just help the court in being an amicus. Forget about this case.
One case I have found in such a case.
Yeah, different high court. You have to search different.
One case she has taken in this alimony, but she has not turned up to pass the proceeding. She has come up straight away and she has also not cooperated. In that case, the court has because case is fast.
In one case, I have also allowed. In one very harsh case that was, I have also allowed. But this is a situation where find out some judgment.
I am ready that if you not want to continue, I am ready also to make you the permanent alimony.
Because it is not 482 petition. To meet the ends of justice, anything can be passed. It is a petition
482.
482. Okay, 482.
So under the POSCO Act, my lord, victim cannot be repeatedly called to the.
That is again 33 clause 5. 33 clause 5. And all these technically they don't know, they don't have a case. But how to get out of this catch 22 situation?
Only that the marriage is the option. If you will give deposition against me, that I will make.
I know. Find out some way out. We'll see. 1 week after, find out, 2 weeks. But definitely come with some judgment or some, and a written submission. Yes.
46.
Date, which date you are giving? Huh? And any similar matter comes on the same date you fix, so that all the matters will do. Yes. Yes.
46.
Yes. 46. What is that?
46 prayer is to quash the affair. Earlier matter one anticipated bail was there, that 7813 of 23.
Rejected.
Order dated 4/9/20.
Rejected, huh?
For that reason, he has filed CRMs.
Okay. He is taking 2 weeks time to cure the defects. Has he cured the defects? Huh? Right on. By the order dated 9/5/2024, this court has granted 2 weeks time to cure the defects pointed out by the stamp reporter. The defects are not cured as yet. None appears for the petition. Hence, the petition is dismissed. Yes.
47.
Requires already filed, my lord.
Service. Service complete. Huh?
No, awaiting.
Awaiting service. Huh? Service. Service on respond number to awaited. Least the matter after 1 week. Yes.
48.
On the impression that requires is filed, but in fact it is not filed.
Hmm?
On the impression my lord requires is filed, but in fact it is not filed.
Will you file
My
it?
lord will file requirements.
Requisites pursuant to the order dated 7/5/2024 has not been filed. Has not been filed. Mr. Mahapatra seeks one more opportunity. Lease the matter next week.
Interim order is there, my lord. You
Interim
will
order
see.
to continue.
Deeply.
But do it,
Yes, Lord.
Your
Tomorrow
office has
by
to do it.
tomorrow,
I know
it will be
you are so busy.
But
You
by
have to
tom-
instruct your
I am
juniors to
sorry.
get it
I am
done.
sorry, your lord. I am extremely sorry that.
All right. Yes, so- But you have to tell your office juniors to.
Today, my lord, I will file it.
You have to
I
be
will try.
careful about it.
My lord. Deeply.
In fact, it's junior's job.
My lord.
It is, yes.
Deeply.
49.
Yes.
Lordship, the petitioner challenged the cognizance order, Lordship, dated
Yes.
18/10/2019, and the cognizance order against that is the case of the matrimonial dispute, Lordship, and the petitioner
Charge has been framed or not?
charge has not been framed.
Okay.
Lordship, in this case, Lordship, the one Vibhuti Bhushan, the entire allegation against the husband of the informant, one Vibhuti Bhushan Mahapatra.
Yes.
In the meantime, while FIR has been registered, the police has followed the, I was submitted notice, fatwa notice has been issued in against all the family members of the Vibhuti Bhushan Mahapatra. And thereafter, the offence are 307 and 493, 313 of the IPC are there. But the all the offences like 457, 493, 313, 294, 307, 323, 506, 34 IPC is there. So like the offence 493, 393 and 307 is not applicable in the particular the family member of the Vibhuti Bhushan Mahapatra, and Vibhuti Bhushan Mahapatra is arrested and religion bail achieved. And thereafter I was complied the fatwa notice, all the family members. And thereafter the charge sheet has been submitted and the court had take the cognizance against all the family members, and the notice has issued in against the IO that I was submitted the final power and fatwa complaint, and all the petitioners has not got the bail before the court, and because the fatwa notice already been served and they have fatwa before the police station. So after notice, after court had taken the cognizance, notice has been issued the members, all the petitioners. So they have not complied the because fatwa 307 is there, 313 is there, but 313 and 307 and or the 493 is not applicable of the family members because there is a relation between the
What do you want? I don't follow you. What do you exactly?
So like I went to I am challenged the cognition order. So my specific allegation is I want to face the trial because all the
Who stops you?
so because I have no right to because notice has been because earlier I was complained 41. The court has
Are you on bail or not?
no because last order lordship I am reading the last order lordship page 36 lordship.
Your grievance is again not getting bail, or your grievance is passing of the court?
No, lordship is grant the bail directed to surrender religion bail. That lordship I will be ready to face the trial.
Therefore, you file.
No, because there is no specific allegation against me. Neither
what do you say?
neither I have the miscarriage.
Already his higher offense is added. Suppose
that judgment, two judgments. What are those two judgments?
Because
what is that? Agarwal and Mr. Ragada. What are these two judgments? What Agarwal and give that two judgments. You are entitled to bail. I'll observe it and dispute it.
Yes, lordship. If lordship has the observation because I will surrender and
Susila Agarwal and another Pravakar.
Lordship in this 41 notice already.
It's all right. I understood it. Your problem is that Susila Agarwal and that what Pravakar.
That is not applicable. Susila Agarwal.
Right. Right. And petitioner has challenged the order dated. Petitioners have challenged the order dated 18/10/2020, 2019, passed by the learned JMFC in GR case number 265 of 2019, whereby the cognizance of offense under section so and so has been taken against the petitioner. The counsel of petitioner submits that the petitioners during the investigation the petitioners were given 41 notice by the police. However, after filing of charge sheet, graver offences have been added. Therefore, he apprehends that once he surrenders, they would be taken into custody. Hence, he seeks indulgence of this court. I am not inclined to entertain this petition at this stage. However, liberty is granted to the petitioner to appear public surrender before the court below, move appropriate application before the court below for grant of bail by relying upon the judgment pronounced judgment of the Honorable Supreme Court in Susila Agarwal and out judgment Susila Agarwal and so on. Susila Agarwal and so on. If such application is made to the trial court shall decide the said application on the same day. On the same day. Yes. On the same day. With this observation, the petition is disposed. Now, we have to read that. Thank you.